I mean,
seeds the field with
Yeah.
this,
Let us know when you're ready.
Yums. It
guys
hasn't
have
been
to
too
get
bad
that,
the last,
no,
there's been years where it's like you can't even
Sound
open the
on.
windows
yeah,
because it's really bad by us, but
he
So
hasn't
we
done it
ordered
this
a-
year as he
A
used
mic
to, so
extender for this.
he probably had the soil
Okay,
tested.
so
You
now we'll
didn't
be
need
able to
it,
get
yeah.
like a mic down closer to like when people are speaking. So we heard that people were saying.
I never
it was
talked
hard-
to him, but I
Hard to
talked
hear
his
some
wife.
people.
Oh,
So
okay.
Really nice.
Yeah,
So,
for this kind of stuff, we
really
won't need it, but
agreeable.
when we got everybody in here.
I don't
you
know, some people are soft spoken at times.
We just have to remember to speak up.
You got it.
We all look like
I
we've
know,
been through
everybody
war.
looks tired.
We all look tired.
I have people in, I just need to get the sound to. Hope I still have people coming in.
That's right. Keep us in the mind. Okay.
Hey, Scott,
Hey, everybody.
just a second.
Five people aside from Scott Brown.
Scott, can you, hello, I want to see if the speaker's working.
I got stone in the face.
I can hear you. Can you hear me?
Perfect.
Sorry, we were having technical difficulties.
Oh, yeah, yeah, you're right.
Just need to get the video.
So everybody can see you when you're presenting.
Yep,
You don't know there's a hole, there's a hole over it, I think.
Yeah.
Oh, yes.
here we go.
Perfect.
Of everybody in.
All right, so we're ready.
I'm ready.
Time is 5:35. And I call this meeting of the Policy Review Committee to order. So first up on our agenda. Got it up here, sorry. Is our check-in with Scott Brown, Neola. Scott?
Thank you. Yeah, thank you very much for allowing me to come today, and thank you for allowing me to be here virtually. We have this was scheduled before this meeting, but we have retired teachers and other teachers or administrators from McFarland here to visit us for a night, and so we're enjoying time with them. Ironically, one couple that's here met at Watertown High School and were married afterwards. They're proud Goslings. I wanted to bring them up in the background here just to make that more legitimate, but they're all at a restaurant right now, so I thought it was really interesting that they were here, and they speak very highly of your school district and everything that you did for them years ago, obviously. I wanted just to do a check-in with with Neola. This is not a long presentation, but I wanted to put my thoughts down in writing, so I'm going to share my screen. Or else, Lynn, you can share the presentation. Right now, I think I'm disabled from sharing my screen, which obviously makes since I'm a visitor to the meeting, but you can either enable it or share it, and I'll go through it.
I can share it.
Okay, perfect. While she's doing that, I thought actually covering topic B would be fairly important. So I'll just talk to that. The Title IX policy that Neola has put out, which is really only applicable to about half the states right now in the US, because it's been challenged in court, in multiple courts, and different states have joined onto it, generally around party lines. We didn't think it would affect McFarland, it would affect Watertown, but in the end, the Kansas Circuit Court, which is Circuit Court 16 in the state, ruled that if anyone in your district is a party to the groups, in addition to the states, the groups that are concerned, those groups have until July 15th to notify the circuit court that they have students in your district that they feel this is would apply to. So we really wait until July 15th to find out exactly, what districts will be affected. We also just received, honestly, probably an hour before this meeting, from our national attorneys, saying that it wouldn't be practical if a student that's a part of these groups, the groups, one is probably the most common one for Wisconsin is Moms for Liberty. If they're active in a part of your county, or they have membership with a student in your district, the national attorney is suggesting that you really can't just exclude a school or a student, that you have to look at what happens after that. So if there is no student that's identified in the Watertown School District, the attorneys feel like, out of risk of facing a lawsuit for not enforcing Title IX, it would be in your best interest to approve the policies. So it's been really interesting across all our states. We have a lot of, different conflicting information. We'll certainly keep you informed of that. We're really waiting again for 4 days until we see the list that we then can respond to our various clients. Obviously, Title IX, whether it was under the Trump administration or the Biden administration, has certain, I think, political implications that people are sensitive to. But the recommendation from at least Neola attorneys is, if there's not something that prevents you from putting it in place, that you should put it in place. And either way, you should continue with the training that's required under Title IX for your employees. So that's really the status of that policy. Everything that's been debatable in the policy has all been about gender specifically, and some of the new definitions of gender and gender identity and transgender, and how it might impact schools. I want to emphasize that from Neola's perspective, we work in Iowa, in Ohio, I should say, and Florida. We work with states that are, easily identified with either political color of the spectrum, and we are neutral. We don't have a position. Our position is to help you figure it out. So the policy that we currently have that you may be looking at tonight, is what we feel should be in place by August 1st to be compliant with the federal regulations, unless there is something happening legally where it shouldn't be in place, and we'll keep you informed on that. But at least for now, as of the 11th of July, Wisconsin districts should be compliant with Title IX by August 1. The risk for you is that if you aren't compliant, someone could file a civil rights complaint saying that you didn't meet the compliance, and that could be a really expensive proposition for any district. So I don't have absolute answers. My suggestion would be to look at it, possibly approve the policy, and then hold off on formal board approval, committee approval, but formal board approval prior to that date. We also would always suggest that if you have additional questions, that you can talk to your own legal counsel. The legal counsel we've been working with has been Hush Blackwell, which covers the entire US. They've given us a lot of counsel on a national level. And then we use Renning, Lewis and Lacey, which represents about 180 Wisconsin school districts. And we're also, relying on them. We send updates in particular to Jared, just to give him guidance as we see it along the way. But certainly districts, superintendents have been put in a really difficult position, on this matter, because people have strong feelings on both sides. But I think unless there is clearly a reason for a district not to approve it, the risk of not approving it might be greater than the risk of approving it based on what could happen if you were somehow identified through either a parent complaint and of not being compliant with the policy. So,
Scott?
Yes.
Good evening. This is David Schrader, a committee member, and I did take the time to read the 26 pages of, I think this is policy 2264. And I feel like you jumped into your presentation, I don't want to say skipping a few steps, but honestly, I wasn't aware that there was any, what's the right word for it? Additional factors surrounding 2264. So it sounds like what you're saying is that 2264 is recommended by Neola. If there are open cases in a state that may contradict what's in 2264, you're saying hold off on it, but if there's no open cases in a state, then you'd recommend proceeding with it, given that by August 1st, we could be out of compliance with federal law. Did I understand that right? Because I feel like you jumped in and I wasn't even aware that there was a backstory to 2264.
Yeah, I mean, you got it exactly right. Maybe a little bit more nuance. So normally circuit courts, which are spread across the United States and are just below the Supreme Court, they operate on a state basis. So a number of states have already obtained injunctions to not implement this policy. Wisconsin is not a state has joined that, and there hasn't been in our circuit court any injunction against putting this policy in place. So we thought it was kind of simple. And in our Neola ecosphere, we knew we would then have Michigan and Wisconsin that should get these policies in place, whereas Ohio, West Virginia, Indiana, and Florida should hold off because there was an injunction. And sort of the surprise case out of the Kansas area circuit court, because circuit courts in some ways can have power over the entire United States. This particular circuit court said, if you have students who are involved in one of these three groups, one is Moms for Liberty, one is, I don't remember the name, but it's actually a group that Governor Walker heads up across the state, but it tends to be more about college campuses. And then there's also a group about women athletics who are concerned about, gender issues in terms of athletics. That tends to be more as well on a college basis. But Moms for Liberty, which has chapters throughout Wisconsin, they potentially could list any district in which there was a member who had a student on July 15th. They're required to report it back to the judge. And when we get that result, we're going to inform our districts, particularly in Wisconsin and Michigan, because the other districts are all on hold, that they should hold the policy. The recommendation from the national attorney is it's not possible for you to limit it just to one student or one school the student is in. That board policy has to be enforceable across an entire district. And they believe it's defensible to say if there's a student that's identified by July 15th that is in the Kansas Circuit Court, then and that student is a part of your district, then we recommend that you would hold off on the policy. But we'll know on July 15th.
Yeah, so Scott, I already was made aware yesterday that we do have someone as party to that. And so talked with our local attorneys yesterday afternoon with some more clarification this morning. And they're making a suggestion that we hold off on implementing.
Yeah, I mean, the key kind of is for you, if they can write you an email and say we're a part of it or things like that.
Yeah, they did. They sent the whole notice to us, so.
Yeah, so, but in some way, that name in your district has to appear in the Kansas Circuit Court, the Kansas Area Circuit Court, the 16th Circuit Court by July 15th. If it's not
Okay.
there, they can write you all the emails they want, but it's not enforceable. The court required that, in particular, Moms for Liberty would give a list of districts and schools and students impacted that would support the decision of the court, so.
And we'll double check that.
Can I ask a question?
Yeah.
I was just reading through it before the meeting started, and it does say towards the end, and I might not understand it. It's a sizable document, in some ways. It does say that the names are not required to be specified towards the end of the document. It says you just need to prove that there's a presence of one of those groups in the district. Is that correct?
That's correct. I shouldn't have said names. You're correct.
Okay.
All right. Are there any questions on that? I mean, I think in the end.
Yeah, just one question, the bulk of 2264 as opposed to the quote unquote final rule. I did read the whole 26-page document, and it had more to do with discrimination in language surrounding what is not, and complaint and resolution, investigation, etc. The definition of who can be discriminated against was a relatively small portion of 2264. Did the final rule mainly impact the definition of who could be discriminated, or what gender and sex and what Title IX applied to? Because I'd say 23 of the 26 pages had to do with more administrative. How are we going to go about investigating and resolving and designating, you know, the lead investigators, et cetera, et cetera. So I don't want to say it was benign, but it was certainly not specific to any class of individual. I mean, I could be discriminated against because I was a white Anglo-Saxon Protestant, and 23 of the pages would have still applied to me. Is that the part that Moms for Liberty and or the attorneys have an issue with?
Yeah, I
The
mean-
final rule is who is included in a protected class?
Yeah, so I mean, obviously I'm not an attorney, but I think the law that the regulation they put in place was based on a Supreme Court decision that said you could not discriminate against gender or gender identity. But the way 2464 is written, this is the whole crux of it. I mean, 2266, which you don't have necessarily in place because you aren't with Neola, but you probably have a Title IX policy currently, didn't provide the same definition. And the biggest change is that if there is what they call a de minimis offense against somebody based on gender or gender identity, that's something they could bring forward. And that wasn't the case under the old Title IX policy. So it's really, I think overall, the issue of the policy that I've seen relative to the court cases is really all about gender and gender identity and transgender. Those areas were strengthened. And then they also provided more procedure. They actually provided some things that were easier for smaller districts, like the old Title IX policy required you to have all these roles that had to be separate. The new Title IX policy, especially for a lot of Wisconsin smaller districts, I mean, I have one that's 65 students. You can imagine trying to find, you know, all the different roles. They allow those roles to be combined. They give more power potentially to the superintendent of the district to be the final review, you know, of that. So there were some things that I think at least helped smaller districts in the new policy, but the main thing that has to be ironed out in the courts is whether the Supreme Court decision from years ago defining gender in a more broad term, and now the Biden administration through federal regulation pushing that into Title IX, whether it's actually going to stand or not. It's going to go to the Supreme Court for sure. If you actually, in my opinion, as a former superintendent, if you do end up with a student that then results in a school, your school, you're probably, actually in a better place in a district that just has to go forward with this either way, because there's still a lot more lawsuits along the way. But our recommendation is still prepare the training. So you're at where you're at. Every teacher has to be trained to recognize the potential discrimination under Title IX. You have to have people trained, but your previous policy will be enforced under a situation where you can't really vote or proceed with new Title IX policy.
Okay,
All right, thank you.
And I
Just a second, Scott, there's one more question.
I guess that begs the question, do, nothing necessarily for here tonight, but do we need to, and Jared, do we need to review 5401, 4185, or 4181? The existing.
Yeah, I haven't looked at your existing Title IX policy, but almost every district in the state used either the Wisconsin School Board policy or Neola policy to form
Right.
the
Or-
policy. So I suspect it's,
Yeah, our old policy is under compliance.
And the reason I asked that is that we are adopting, we're going to approve the language and adopt the book. Since we're approving the language for this, if we do with this would sit until we adopt the book, like we have the other deal.
sure, but I understand we're not gonna push this forward as part of the.
Right now.
Right.
Right,
So it wouldn't be in the.
I guess
Yeah.
my,
Yes.
Yes.
my suggested course of action on this particular one, it is to become familiar with the document. But if it's not quite as settled, if it's not quite settled in the court system, I don't know if we should dedicate a ton of time to it for the moment.
Craig, to echo that, I did attend the WASB seminar on Title IX, February of 23. And the answer, that was a packed house. It was a room no bigger than this with about 400 people in it. And they said, there's no way to be right and there's 1,000 ways to be wrong. Because every single day there's a new lawsuit, a new interpretation, a new federal ruling. And the one thing that from my perspective, and I'm not necessarily risk averse, I just don't like being on the bleeding edge of anything. I have no reason to invite controversy into our district, one way or the other, when we have bigger fish to fry from my perspective. In which case, I'm more than happy to table it and wait for the dust to settle. And then do something that's more certainly something that we can live with and all of our students and our teachers and our families can live with. Than trying to be out there forging ahead with a new precedence that isn't even tested in the courts. So that's my 2 cents on this policy, and pretty much any policy is. Why bother beating your head against the wall just because it feels good when it stops? I mean, let's focus on the things we need to focus on.
All right, any other thoughts or comments? All right,
I would concur with that comment. Thank you for sharing. I think the only thing you could do to prep for this, I think there'll be districts, I mean, it came out pretty late, right? So there's some argument to say that if you give a regulation to districts in mid-June of summer and expect them to get all the training in place and be ready by August 1, there's some argument to say that's really hard to do. What our attorneys have said is the suggestion, not so much for you as a policy committee, but more for Jared and the crew there, is to continue with the training, show you're making a good faith effort, contingent on where it's going to shake out, and then once you know more, then the board could approve the policy. So I think the question that I would say for you to refer to legal counsel is, if you aren't a part of the group as a result of July 15th, then you have a hard decision to make, because the expectation of at least part of the citizens you represent is going to be that you have a Title IX policy in place and meet federal regulations by July 1. So I think what you said was really accurate, but I would encourage you, not to freeze the process, in particular with training and, getting folks ready, and have a document ready that when you want to approve it, You can call a meeting of your policy committee, you can call a meeting of your board, and you can explain to your public that this is what we have to approve. It's not our choice, but this is what's required, and this is what our legal counsel is recommending.
Jared, you're clear on that? I mean, you know how that, and Fred, how that, how where the rubber hits the road on that if we don't move on this policy, you have, you're crystal clear on that, you need guidance?
No, I think if you're. My understanding from the committee is that we're gonna follow our attorney's recommendations. And right now, where we're sitting, they've said that we should, wait and see how this. Case pans out because we're an identified party.
Okay.
They too recommended that at least for. The people who would be considered reviewers. Within that, go through the administration training. We already have those people started in that training, the free training that was through Renning, Lewis and Lacey. They're gonna finish, there's 2 more, they're gonna finish that training, and then we're just gonna wait and see. Not really implement anything until we know more.
All right.
If you guys, Renning, Lewis and Lacey, yeah, they're,
I think you sent. or-
yeah, I sent it out.
Yeah.
And-
The notice for it.
Yeah, and they've videotaped it too. They're all done. I'll capture all those videos and for anybody else who's interested, because it was also for board members and everything else. So I don't even know if any of you have that training or not,
I
but
think I emailed you about it
Yeah.
back before it happened.
yeah, you said that you weren't able to, but you'd like the videos. So.
Yeah.
I would prefer, I would like the video if I could get if I could get access to that.
If there is one, Jared, maybe we send it.
Yeah.
I'm not sure.
Yeah, I don't think that they're gonna have videos until all of the training sessions are
Okay.
done, and then they'll put a package out that says. For, for districts who were registered, here's the videos.
And I guess
All right.
the good news is as a former business official of a district, they aren't charging for the training. I mean, they're obviously doing it for free because it's in their interest to promote their law firm. But I think, the good news is any training you do isn't costing you money.
Scott, we have a very packed agenda tonight. Can we go back to the item A about the Neil check-in?
Absolutely. So.
Alright.
You wanna
That's
move it up?
maybe why I was confused.
Yep.
So just to remind you that Neola is a really cooperative policy development. We represent 340 of the 425 districts in Wisconsin. We've been in Wisconsin 33 years. We have 11 retired superintendents that work with districts. And our policies for Wisconsin are written and approved by Wisconsin attorneys, Renning, Lewis and Lacey, representing about 180 districts in the state, not all Neola districts. We don't share our client base. And we have national attorneys, Hush Blackwell, which work with, in particular, like national finance issues, which is called Uniform Grant Guidance, and also EDGAR, which is the standards from the Accounting Association. So they help us draft those, and they help us with Title IX. And then as well, we have an attorney on board at Neola that sort of helps us sort through everything. So I want to just give you that background. No need to discuss it further unless you have questions. So my thoughts on your particular situation in terms of working through your policies. I think it's always good. This is something I haven't shown you before, but to think about the purpose of bylaws and policies. There are some that are absolutely required by statute, locker room surveillance, you have to have a graduation policy. Some are directive, like if you have rules about social media and what teachers can share, or even what students might share in violation of your social media policy. Another example is board vacancies, which you're given a lot of latitude on how you fill those, what process you use. And then some are just informative, so people can look and go, oh, how do I complain about something? Or how does veterans as volunteers work in your district? The key thing to remember about Neola policies as part of your contract with Neola is that we have put in writing that we will provide legal assistance defending any defect in our policy. So we always encourage you to take care when you edit our policies. There's been a lot of, I would say, legal expertise, and in particular, school law expertise that have been put into these. Potentially for us to help defend something that would not be appropriate is expensive. So we know that, and we spend a lot of money. I would say, just because I'm now working more with Neola out of their central office, I'm vice president now of the company, and also working in Wisconsin with a few districts. I would say, like, just for example, the Title IX policy, we probably have $30,000 to $40,000 in legal expenses to help prepare that policy. We call a summit from all the states, multiple national attorneys. So Neola really tries to do its homework. So when you look at our policies, on some of them, like the informative or directive policies, you have, some flexibility to make changes, but if you go too far into some of the required policies, non-discrimination, Title IX, things like that, the risk is that we would not support you if you, for some reason, somebody identified something that you had put in that wasn't a part of our policy. You can move on, Lynn. So let's do just a review of where Watertown is right now. You started October 4th of 2023. We thank you so much for the opportunity to work with Watertown. You pretty much in Watertown are surrounded by Neola districts, so that's a lot of good networking for Jared and other administrators. You all have similar policies. You make different choices, but you have similar policies. Right now, you have approximately 80 policies drafted to date that are in a cleaned up folder and can either be approved through the first reading or by the policy committee has approved them to that point. As of today, you've missed parts of 2 regular updates and 3 special updates. When we get an update and we can still apply it to a section you haven't touched, we do that just to make sure that whatever we have updated, we can have you do. But for example, maybe like the board bylaws, there may have been updates to that, which we have to wait until you get the whole package approved to apply those updates. Right now, and you won't accept them all because Neola offers a lot of policies that districts say that's just not, that's a policy that's not required, and we have we don't want to add it to our policy book, but you have around 380 templates left to consider. If the goal is for you to complete in 2 years, the committee and then the board need to move approximately 30 to 35 policies per month. And then when you finish with that and you get your policy book in place, you will have parts of 4 regular updates, and I'm estimating about 5 special updates, like Title IX, or there's a reading update coming out based on new state law. There's a couple other special updates that will likely come out based on Wisconsin specific law. Just to give you an example, it's not unusual for it to take 2 years. I just finished with a district near you, and I'll meet with them on Monday, and we are working now for the board to update approximately 79 policies that were updated while they were drafting. I mean, one of the cool things about Neola, from like my perspective, hopefully from your perspective as well, is you will get 2 updates per year that will take your whole policy book, and based on feedback from the other 340 districts that are in your consortium, the Neola consortium, based on attorney feedback, applying our policies, based on superintendent feedback, and also based on our 11 retired superintendents that see things here and there. Your focus as a committee will just be twice a year on trying to update the policy package. And actually, once you get everything approved, that doesn't take a lot of time, honestly, with policy committees, because normally they see the reason, we list the rationale for the change, but you'll never worry about your policies being, out of date. My caution to you, the final point is, don't let perfection be the enemy of great. I think Neola policies are very strong. As a former superintendent that used them in McFarland, when I would have something go sideways in my district, I would say, 95 times out of 100, we would go to our policies and we would have the right updated policy in place to handle that situation. So I think it's important that as you try to approve 30 to 35 policies per month, perhaps meeting once or even twice, that you realize that you'll have a chance at any time as a committee, particularly during the 10 months when you won't have a Neola update, to look at policies that are important, in particular to Watertown, or maybe changes to Neola that you want to have your attorney explore to see if it can be more varied or provide more information. But the key for you, in my opinion, is that you really work to try to get our package complete, so you'll have the freedom to look at a lot of the other things I know that every policy committee is concerned about or wants to look at down the road. So it's kind of funny. I feel like I'm your coach, but I'm not your coach because you all have more power than I do, right? So I can't really force you to do anything, but as a coach, I would tell you, it's really important to complete this game, to finish this task, and start going over 2 years. You get to so many updates that you've missed. It's not impossible. I have had districts do that, but it's pretty time consuming to try to catch up on all the updates that you missed. I would say the size of your district, the involvement, and I would say, concern and interest in the policy committee is awesome, but you really should try to set a 2-year goal. I think that's a really, modest goal. And in small districts where it's just the superintendent, sometimes they don't even have a policy committee, we'll finish this drafting in 7 months. It's not my expectation, but part of my reason for, asking Jared if I could talk to you is just to really encourage you to figure out a schedule of meetings and a plan, and kind of look at what you're approving and try to get to that goal that you need, 30 to 35 policies per month, so that you can finish the Neola process. I think I have one more slide. Do I? All right, so this is the cool part. Once you finish, with Neola, again, there'll just be 2 updates per year, and they will update your entire policy package based on all the things that I said. So when you hear about the legislature putting a new reading law in place, or when you hear about the legislature saying that class rank is now going to impact how students can go to the University of Wisconsin, all those things you want to think about them when you read them from the School Board Association or someone else. Neola's going to be on top of it, and they're going to be included in one of our updates, or if we need it sooner, it's going to be a special update. Then finally, we're going to keep your website and your policies up to date. It's not Lynn or Jared's responsibility. As long as you approve the policy, we're going to retire your old policies, store them where people, in particular in the district, can see them, not necessarily the community, but they'll be on board docs. And we're going to track exactly what you submitted to make sure that we produce them correctly, so that that we are following what you as a committee and what you as a larger board have approved. And that's sort of the goal, the pot at the end of the rainbow. That's where you want to be. But I really want to encourage you to really set a hard goal for 2 years. I think it's going to be better for Watertown and better for legal risk in terms of what can happen when you have too many policies out of date. That's my spiel, folks.
Very good.
Thank you.
Thank you. Does anybody have any questions for Scott?
Maybe I do have one. When there's an automatic update, does that have to come back to the board, or is those just those legal things that just?
No, they will come to the committee. The committee will review them, right,
Gotcha,
and-
okay,
and then put them in place and
Okay.
suggest them to the board for approval.
gotcha.
Yeah.
It'd just be on
And
our
the
system.
way we categorize them, at least what I do with my clients, is we show the update, all the policies are updated. I'll put like whether the policy has a choice or whether the attorneys have just said this needs to change in the policy. So a lot of committees really focus on the ones where there's new choices that they have to make. And then they also show everybody the ones that have no choice. And people say if they're interested in discussing that further, but generally committees will say the no choice ones, we aren't attorneys. We're not going to try to necessarily question that unless there's something that's really curious to us. But the choice ones will be ones that you as a committee, probably Jared will bring recommendations. And the choice ones will be ones that the committee will consider. Then they all go to the board, and over 2 votes, they approve our update package.
Good question.
All right. Seeing no other questions, any further discussion on what's going on with, our timeline?
Well, none for Scott.
Not for Scott.
It's more of a matter of 30 to 35 a month is one a day, Lynn.
We got this.
And
Don't worry, we got this.
and I'm not saying that we have to.
We just can't
we have
spend
to
5
lower-
hours on
The
it.
policy, we have to lower our guard to reviewing them, but I think we've been doing a very good job. You guys have been doing a very good job. Policy's been
Yeah.
doing what they're supposed to be doing.
Right.
But we're not at that pace. And does it concern us? Craig, I don't know if it does. I mean, 2
Well,
years, schmoo years,
part-
whatever. I mean,
part of the-
we're getting there.
Right,
And we haven't held up any significantly, save maybe 1 or 2. I just don't know if Lynn and Jared, it's still about bandwidth. And I'm
It
not
is.
saying we have to get there in 2 years. I'm just saying is that we're currently haven't demonstrated a pace to get there in 2
Well,
years.
right.
And are
You'll
we
see,
comfortable with that?
you'll see that we have a plan to get there.
Okay.
By the end of May. And we're gonna stay on that plan, but you make a good point. We can't spend 8 hours, discussing those 30. I mean, or we're gonna have a, policy committee every week.
Yep, that's my.
And I will tell you, I don't wanna do it. I will give them to you, you guys can discuss them and then, or you can make me come, but I will be a grumpy bear at it. You know, that will be a difficult situation for me.
Yeah.
And,
You guys don't want that either, I know that.
I think we, because we have, that particular discussion coming up later on in the process, for on letter E, the Neola policy development process. Maybe we'll continue that discussion later on.
Okay.
Thank you all. Appreciate you.
Thank you, Scott.
Actually.
All right,
Okay, bye-bye.
all right. So we jump into some of these policies. Letter C. First start with, policy 3210. In the first group, staff ethics. I'll start with, some of the thoughts that I had, and then we'll just go around and see what other folks thought.
So I have a question, Craig. Are you going in the order by which we see them listed down here or the way that they're listed in the bullets?
Good question.
Because you started with the first one that's kind of
Well,
attached.
Well, we can start with,
So I just want to know which order so that everybody knows the order we're going in.
well, we can start at the bullet points then, if that's what you want.
I'm just asking the process.
I would-
What's that?
Might be easier for the minutes.
Okay.
Oh, I see. I was like.
Right, 'cause
They're listed.
Right, they're listed in the
Yeah.
agenda by bullets, but then the attachments are in a different order, and we started with the first attachment.
All right, well,
I don't care which way you want to do it.
sure. We start with the non-discrimination and equal employment opportunity. And this one, to me, was a little bit of a heavy hitter. Specifically, under reports and claims, complaints of discrimination. It's basically, there's some language on the second paragraph that's just started with discrimination against an individual based on their sex, including gender status, sexual orientation, and gender identity is discrimination in violation of Title VII. Specifically, gender discrimination on the basis of sex stereotyping, gender nonconformity, constitutes sex discrimination. This is true irrespective of the cause of the person's gender nonconforming behavior. Employment actions based upon individual sex could be suspect and potentially impermissible. So that one statement actually is what this whole particular policy seems to be centering around. And that's where I get a little bit confused. And I would seek some more clarification in that respect, I guess. Because, you know, the specific statement, including, which is in parentheses, including gender status, sexual orientation, and gender identity. And then the other statement on here, specifically discrimination on the basis of sex, stereotyping, and gender conformity constitutes sex discrimination. So what is this alluding to? Is what I need clarification on. That specific language, just to make the committee aware, doesn't exist in state statute, nor does it exist, as this alludes to, in Title VII or in Title VI. So if the state legislature and federal government don't find it necessary to put this kind of language into law, why is it necessary for Neola to recommend this language into policy?
One thing I think I did see, I don't know if that's part of Title IX, which obviously that's where these things get, I know,
Right,
kind of washed in. I remember seeing that in one of the things that Neola gave us on the updates, but I question this specifically. I don't understand that.
right. And the question I would have is, does this particular statement have a lot to do with the use of pronouns, for instance? In which case that is considered compelled speech. Compelled speech, last I checked, is also a First Amendment question that's also working its way through the court system. If we're going to go down that rabbit hole of compelled speech, I feel this part of this particular policy is opening up some liability.
People there, and I would, and I'm just gonna refer to the US Equal Employment Opportunity Commission. It did have clarification on that. Does Title VII protect employees who work in places where state or local law does not prohibit employee discrimination based on sexual orientation or gender identity? Yes. It's a federal law. Title VII applies nationwide and protects employees from discrimination based on sexual orientation or gender identity, regardless of state or local law. I'm not a lawyer. I don't play one on TV.
Me
No,
neither.
that needs to be in there. for
But
sure.
I'm just saying that, I want to make sure that we're not going against, if there's legal precedent that we don't know.
Well, that's why I'm saying, there's enough there for me to question whether or not this is,
And here's my take on it, Craig.
Yeah.
I just this week, I have an online employment application for my company and asked my attorney to review it.
Hmm.
The very first paragraph. The company does not discriminate on the basis of race, color, creed, religion, sex, including pregnancy, childbirth, and related medical condition, age, national origin, disability, marital status, sexual orientation, gender identity or expression, military status, genetic information, or other characteristics. I have no idea what is in the state law. I don't. I can tell you that my attorney specifically told me to put that on my website to cover my ass. I don't see any reason why we wouldn't be well advised to do the same thing in our policy, because if we asked our attorneys if this language should be in there, they're probably gonna tell us the exact same thing that my attorney just told me on Monday of this week, which is leave it in there because you don't want to come across as anybody who would discriminate against anything for any reason
Sure.
except for their capabilities and qualifications.
I don't disagree with you when it comes to, the consideration of employment.
This is about employment.
This
This is Title VII.
is, this is, well, it's also about disciplinary matters regarding.
It's still employment.
discrimination. Sure, it's
We've got
employment,
Title IX.
sure. But
Both
that's,
Sam and Tina have their hands raised.
sure, go
Craig,
ahead.
are you
And the-
questioning, you're not questioning including gender status, sexual orientation and gender identity? Did I
No,
understand? you? You're
well,
not questioning that?
The language isn't in,
Yes, it is.
it's in the
I'm pretty
Title
sure,
VII,
I'm pretty sure it's in,
because I printed it all out and read through it, I see it.
I'm trying to.
So, Diana, or Tina's got her hand raised, Diana does and Sam does.
Okay. Go ahead.
If you haven't seen them.
No, so my quick comment was that what Scott had just said a few minutes ago really resonated with me, that if we start making bigger changes, we open ourselves up to potential problems, lawsuits, etc. So my recommendation is that, or my thought, I'll say, is if we're going to start questioning, pulling out pieces like this, that we take it to an attorney or to Neil, go with a bigger being than us. Let's not spend this time today going through it, because if we got 19 on the docket today, which means we're 12 behind.
Uh,
So,
I hear you, and
That's why I know that there's very much points of consideration that we need to bring up. But that statement really resonated with me, that, okay, we really gotta be careful, especially in something like this, that certain words and things could have huge impacts that we aren't aware of.
Right, and that's why I'm seeking clarification on it, because, if this is implying, if I'm reading through the rest of this document, it's implying that if somebody misgenders somebody, potentially, they could be terminated, just like that.
So what you're saying is, you're recommending that this go to an attorney or something like that
I
for guidance?
don't know what the
So I'm just
course of
saying, if
action
that was
is.
the recommendation, then let's move with that and move on to the next thing, because then we're looking at, unless there's other pieces to bring up to also bring to the attorney, so let's put those out on the table.
Mhm.
Instead of trying to talk about different words, just for the sake of time.
Sure, no, I agree with that, I respect that. Sam?
Well, I suppose two things. I think it's reasonable. The last meeting that I was sitting in on for policy, there was a great deal of discussion about the specific meaning of specific words and whether or not they should be included in policies across the board. And I think that if people have concerns, they should hear that out. And I think the purpose of a policy committee is to have those discussions. So I think it's very reasonable to have that discussion. And I think that we should kind of across the board, we should have that respect for each other, whether we're on the board, whether we're on the committee, off the committee. The other thing that I was gonna bring up is, regardless of the first sentence, first two sentences of that second paragraph, the third sentence is what really concerns me. It says, this is true irrespective of the cause of the person's gender nonconforming behavior. That's very concerning, because a person could actually have malicious intent behind supposed gender nonconforming behavior, like, and again, this is kind of a Title IX example, but I think this carries across the board, what you saw in Loudoun County, with the tragic incidents that happened in two separate schools and girls' bathrooms. So I think that that is something that should very seriously be considered. Cause of nonconforming behavior is not always, it can be malicious, right? It can be actually deceptive, and a person can use it to abuse other people. So I do think that regardless of where you go with that, I don't know that that third sentence should be included at all in this statement.
And whether or not it should or should not, I guess is my confusion. I guess that's all I'm saying.
Yeah.
Perhaps maybe we should.
Tina has her.
Go ahead, Tina.
So, as a committee member, we're embarking on this journey, and to be honest, I'm very frustrated by this discussion, because this discussion and this deep dive into these nuances basically negates what Scott had just said. I agree with Diana as far as, didn't he just say that they had these attorneys looking over it? And if this is something, I had brought up a question regarding something that had been crossed out. Okay. that's on a different level versus picking apart every single wording in this. And it is important for us to be able to follow through and to be able to get through these policies the way that he outlined it. And if Neola's already had attorneys looking at this, just feel like it's very redundant. Um, and as far as maybe this is one, once we have everything adopted and that needs to be put on the docket as far as that's concerned. I guess that's just kind of where I'm at with it. The only question I had on it was, I think this is, I'm trying to go back and forth between my email here. As far as the responding to complaints in a specified number of days, that was my question as far as that's concerned.
Okay, thank you, Tina. Jared?
So the question I have, and it's more for administrative purposes, is if we're going to want an authority source to kind of vet this for us, and we're not gonna use Neola, who am I to go to then? Because we already have an authority source of Neola who has shared where they get their legal information from, 3 sources. If you don't want them as the authority source on these, who am I going to? And I need the, do I go to the district's attorneys that we have been going to with Bueller Vetter, or are there somebody else that you would like me to go to? I just want to know, because I don't want to keep coming back with another authority source or another authority source, and then, not know where I need to go. So
Well, see-
I'm wondering that question.
Here's where I did, want to push back on that is, this is our policy. It's not, yes, this is a recommendation from Neola. But it's still our local control and authority to be able to put policy into practice. And if there's something that we need to work on, to come together on, we need to figure that out, because we want these policies to stand somewhat the test of time. And be before too long, and also from a legal standpoint, I don't, if there's enough question that maybe that this is a court system issue, why are we putting it into policy?
Well, Craig, I guess what I was saying, I was not negating you guys as the ultimate authority source. It's just you had shared, I'd like to have attorneys look at this language or give us a different people or reasons why.
What
I
I'm
want to know.
what
who
I'm
it's
asking,
from.
okay, again, this goes back to an earlier discussion we've had about some sort of a legal background or context behind why we would go forward with an additional change. And it's not necessarily that, you have to speak to an attorney. I noticed that there's language in this particular Title IX policy, 2264, that we should be asking Neola when we have questions regarding this particular policy. So that's a service that may be available for us to actually tap into and seek some clarification on. So there's that. The other part of it is, we don't, whenever a policy comes to us, that's completely different, it's always been our board practice to have some sort of context behind the rationale. Why do we need to make this particular change? And why do we need to make that change now? Because if that's the case, what's wrong with the old non-discrimination policy? That would be my question.
And I would answer that, Craig, with the definition of discrimination and who can be discriminated against has been changing for at least the last 20, if not 40 years. And let's say it changes, I don't know if it changes annually, maybe it changes every 5 years. But you're right, we weigh in when it comes to certain portions of our policy that have to do with, let's say, detentions or bullying or dress code or cell phone use or what have you. But these, in my opinion, these blanket statements that are based in state law precedents that have been reviewed by attorneys, Neola's or ours, are well beyond any of our competencies to say this word should be in and this word should be out. And anytime I've run into one of these things, the attorneys govern because they're the ones who are briefed and experts on that subject matter. Now, I have no problem saying, hey, Neola, are there any options to this paragraph? But there's nobody in this room who is better off striking or adding words to this than what was put in front of us. And it doesn't matter if we're elected by the public or not. We're not qualified to take out or put in words into some of these paragraphs. That's just flat me either. I mean, I'm not saying it's me. I'm not saying it's you. We're not the experts in case law. Even if we read up on the case law, we're still not attorneys and experts in case law. So I would never get that far over my skis to think that we can strike a word because we don't like it when it comes to certain paragraphs of certain policies.
Go ahead, Lori.
I guess where I get confused on that is why is it okay in certain paragraphs? I mean, we really don't know. And that's, you know, there's another policy that I questioned, something that got blocked out because it isn't a state statute. So that sometimes I think there is, and take a disregard even just this paragraph. I think if there is something that we question, we should make sure that we've vetted all
No issue answering the question or
Yeah.
asking the question, and then that goes back to Jared's question, which is who would you like him to ask it to? Because Neola's attorneys have already weighed in on it. And if you don't like their attorney's answer,
Well-
then whose attorney would you like to ask?
Yeah, and I know it did say that in the 2264, I did notice that it says that we recommend you consult with
Mhm.
your legal. So they obviously recommend it at times where, and I don't know what the answer is. If we could reach out to Neola, I don't know if that's a option. with
It is an
their
option.
time.
I mean, we pay for their service.
Yeah.
And I just wanna know,
I mean, why can't we, I guess my biggest question is, why can't we ask a question about the language in Neola's policy to Neola? I mean,
Right.
if,
You can.
okay.
I was just asking, is that the source you want me to go to? If it's Neola, well, I will go to Neola. If it's our attorneys, I'll go to our attorney. I just wanted to know which authority source you want me to go to.
I don't think anyone is arguing with you about asking the question.
Mhm.
I think what it is the process by which we want to, and if we want to, if that's this policy, we have certain language that we have questions on.
Mhm.
Then I say, we highlight those, you know, those words. We flag it to go back to Neola, we send it back to Neola and say, hey, why are these words here? We have these questions, and then we move on to the next policy. We don't spend 45 minutes deciding, you know, and discussing amongst ourselves whether we can ask them or not.
Right.
I think that's, this goes back to the initial discussion of keeping this expedited.
I guess I don't disagree with that. So, I mean,
I felt like that was what you were asking originally.
was.
Craig. I feel like you were just asking, do we want to move forward with this or do we want to send it back to? Neola?
exactly.
Yeah.
Thank you.
And we're comfortable with Neola as the source of
I
truth
was
on
just
this.
asking who,
Yeah, that's a great place to start.
Right,
Is
like,
Neola. I think
who
they're
do
the
I
best
go
people
with?
to ask
Right.
initially is like, hey, can you give us some clarification on why it's written this way? Why does it say it's regardless of motivation or regardless of cause or something like that? Yeah, they're great to ask because they're the ones who penned it essentially. And so they can give you insight on why they penned it. That's great.
Yeah, and I think just, this is what needs to be in there legally. These are extra recommendations that we said, but legally they don't need to, and then we can
If-
decide from
You
there.
know, we're already talking about a protected class of individuals. You know, at some point, I just I'm starting to wonder the necessity of putting in some of this extra language. That's all. Go ahead, Diana.
This policy, when Scott talked about the three categories, required, directive, informative, this
Yeah.
policy is obviously required. But to get to my interpretation of your statement is, are all of these pieces to that policy required? Is there a way, and this is just a total informational question, is there a way from Scott to know what policies are required, which ones are informative and which ones are directive? Because as we talked in previous months about different policies, some of them that we talked more in depth were more of directive or informative, not necessarily required, and those have wiggle room for modifications or tweaking to, like what you said, meet the needs of our specific district as opposed to generalities.
Yep.
But in terms of expediting this process, if it's a required policy, and we know that, it's like, okay, this one's required, there may not be a lot of wiggle room, so knowing that at the forefront might be helpful, it's just a thought.
No, thank you. I think we beat that horse to death a little
So
bit.
is that the only questions? we
Oh,
have
I'm
on that
sorry.
policy?
I don't
I mean,
want to
just that-
assume
just-
that anybody else didn't have any other
the-
questions.
that
on that.
paragraph?
Tina did question the.
I did.
Yeah.
Tina, question, what part?
I believe it's this one. Hang on a second. Is this 3122? Is that what we're talking about?
Correct. Page
Okay.
5, like you said.
So my question, yep, that I had sent out the email out earlier today, page 5. So as far as the specified number of days, as far as a reasonable time frame. And so my question there is because in I'm so sorry, 2 following policies, it does state specific timeframes. However, in this one, it doesn't, and it was crossed off. And so I appreciate timeframes and wondering maybe why we cross them off. I just think I think it's in our best interest to have timeframes because then that can set everybody's expectations and keeps
Well, let me,
communication.
yeah, I can clear this one up really quickly and easily for you.
Great.
Our committee asked us to review in detail our complaint procedures with our attorney. You'll see that as one of the ones that we're gonna work through later. And some of the handwritten notes in that Lynn attached just before the meeting, not maybe an hour before the meeting. We were able to, when I say we, it was Margaret and Lynn were able to meet with Dan Vliet to go over his recommendations, having worked with us in our district and understanding timelines from other school districts. He gave us reasonable timelines within that document and asked us to put those in other policies where applicable. And this one would be like that policy. So if you want to know what kind of timeline we would be putting into this, it would be just like our complaint procedure timeline. Does that make
And
sense?
thank you for that information. What's the complaint procedure timeline?
So if you go into
Is that 3362?
yes.
Okay. Okay. All right. Yeah, I just wanted to make sure.
Hold on.
It's in the next group, I think, isn't it?
Yeah, it's in group 2. It's
Grievance procedure,
Grievance.
3340.
3340. Yep.
Oh, sorry. Okay. Yep, that has dates and time. Okay. Nope, I appreciate that. Thank you very much.
But yeah, and then she added a 3340
Grievance with notes.
grievance with notes in the document set. And so her handwritten notes are in there from meeting with the attorney.
So I guess to Tina's point, I do see, as I read through these policies, as a number of you have as well, I do see a recurring timeline of about 5 days for responding to complaints and grievances. I'm comfortable with a time period on the process. I just think that it needs to be consistent across the board if we do.
That's what I just said, yeah.
Okay.
What he suggests that we go with the time frame that's in the notes on
On the grievance
yeah,
policy?
on the 3340 grievance policy with notes.
Okay,
And that we apply that same timeline to other procedural ones like this one.
so that being an action plan of basically 5 business days from the date that are, is it 10?
I think it's
10
10
10
on
business
the notes,
days?
right?
Yeah, it's 10 on the notes.
Yeah, within 10 business days.
Okay. And then in the event that okay, event that the superintendent is unable to respond within 20 days upon written notice, can extend with notice to the complainant.
10 for another
For
10
more
days.
10
And we're waiting for the attorney to give us actual verbiage. He just hasn't given us, I kind of wrote that in.
Yeah,
I guess if we're going to use that as the consistent template across the other policies, does the committee feel comfortable at that time frame, or is there further discussion on that?
Are there any legalities to any of those that we have to do them in a certain time frame for any policies? Are No,
These,
okay, that's all.
these
just
are,
our-
these are
our-
his suggested
Okay.
timeframes.
Yeah.
And well within our purview to be able to do.
Do you feel it would be easier for the administration to have a consistent timeline, I imagine?
It
It'd
would
be
be,
kind of in the back of your
it
head,
would be,
you know?
and as I've noted, over the last two that we've had to walk through in the last year.
Mhm.
The timeframes, in this district are really tight.
Mhm.
And you know, I tried to get through in my time, the board tried to get through in their time. We didn't meet our own policy.
No, agree.
We had written those in to follow, but we hadn't met those,
Mhm.
right? And so, Dan's suggesting these timelines, not only for us, but they interact with us on my end and on your end.
Right.
And he knew that, like, it was hard to get information back and to do the kind of detailed navigations that we needed to. So this is what he's suggesting.
All right, so Tina, I think that answers your question on timeframes, for a number of your questions, it looks like.
Yep, it does. Done. Thank
Okay.
you.
You're welcome.
All righty. All right, let's move back to our agenda. The next one on the agenda is 3160 physical examinations,
Once we decide on the other 3122.
3122. Aside from,
The
The-
non-discrimination.
Yeah.
Aside from that one paragraph, was there anything else besides time? The timelines are gonna get filled in. Is there anything else?
Refer back to, look for questions on the language. and then-
yeah, that would be the action item, is to refer that to,
Is that it for that one then?
So there's two things. We're gonna respond to, or ask Neola about that paragraph, and then I'm gonna apply the timeline.
yes, please. Was there any other?
Sam just raised his hand.
Good.
And I mean, I'm not on the committee, so I'm not trying to like overstep boundaries or anything. But maybe a better approach would be asking Neola to clarify what parts of the policy are necessary by law and what parts are supplemental or like,
That we could change.
yeah, like what part, yeah, like if they could even highlight like yellow is necessary, red is stuff that can be altered, or green is stuff that can be altered.
You can use the paragraph that we had in question as an example of, this is, we had confusion on.
Yes,
Yeah.
exactly.
And I get that, and I'm agreeable to that. I just, the question is specific on that particular paragraph
Mhm.
because of the nature of
Oh,
what
yeah,
it's
definitely.
referencing,
Yeah.
so.
I have a feeling that one of the responses that I'm gonna get is where you have choice, we gave you choices. It was this choice or this choice, or a combination thereof, or whatever, because when you go through the process, you have to pick, right? And you see them crossed out, which ones we picked, which ones we didn't, right? Based on our
Yeah.
old policy and or what our thoughts were as we discussed them with our attorneys or whatever else.
Mhm.
That's what we gave you.
And I guess that's why I'm offering the specific line of questioning
Right.
to them.
Exactly.
So-
That's why I was saying, maybe going back to them with a specific is
Oh,
better than,
just do the whole thing or whatever. Yeah, and I understand the difficulty of that and like when you're putting together sentences, where does one thing stop and another one start? I guess I'm just curious about it because specifically that line about if regardless of the cause. I can't remember, I've spent a fair amount of time looking at the EEOC non-discrimination stuff over the past couple of weeks. And I can't remember any language that's specifically like that, so I'm curious as to where that comes from.
Sure.
All right, any other questions on that?
Okay,
Trying
so
to
just those two things then.
Try to move along to 3160, physical examination. So I didn't necessarily have any particular things that stood out to me as different, but I know that Tina had
Mhm.
a question specific to that about drug testing. And I would make note that in policy 4131, drug testing was in our existing current active policy as well. So, Tina, do you have any other questions on that?
Nope, all good. Thank you.
I did wanna ask why no physical, the first paragraph that's lined out. That was in our original policy. I know it is also listed under the state statute as an option for districts, so I just didn't know.
I don't
why we
know
took
that,
That one out,
oh, good question.
about the affidavit for religious exemption, I believe is, well, not quoting it, but. I just didn't know.
Yeah, that's a good question. That was in our existing policy. Yep.
And that's just the first, the one where it talks about additional physical examinations. I'm not worried about that one, just that one paragraph, the long one regarding the.
No physical examination may be required, but
This kind of goes back to the COVID concerns. Partially.
Well, I mean, I don't really have an opinion on it. I just know that it was in our original and it is under the state statute.
If it was
So-
under the state statute,
This was an optional part.
It's an optional part, so I just was
Right.
curious why, since it was in our old one. What does it, what, where, who, you know,
Yeah.
why we. if we
Margaret, can
do
you
want it
answer to
out.
that? Margaret, are you there?
Yeah, I'm here. What, I'm sorry, what is the policy?
3160 physical examinations. They're questioning, the strikeout of the first paragraph there of no physical examinations may be required of any employee who has filed an affidavit with the blank requesting such exemptions. Because, it's on prayer, spiritual heal, accordance, that kind of stuff.
So I am not an attorney. I know that if somebody files a request to have an exemption based on religious or other needs, we usually comply with that. That would be a question that I would need to refer to an attorney on. But I don't know that if somebody's objecting based on religious grounds, I would seek a consult on that. We have had other people that we have cooperated with when it comes with respect to people that choose to seek alternate providers like natural medicine practitioners and things like that. But I mean, that's what we do. And so the choices that we made were in alignment with what we do.
Well, then we should keep it in there.
so if
You guys want to keep it in there?
yeah, if we're trying to. Also, within the spirit of what we have as laid out as Neola process. To try to match up our current policy with as close as possible to the Neola policy. I would argue that should probably be in there until the next review. Where we may strike that if that's necessary. Any thoughts on that?
Tina?
I'm fine on that. If it's in there currently and generally, if you're suggesting, I'll say put it back in because that's what Margaret's doing anyway.
That would be our
It would make
intention.
sense to have it in.
And that's what's in our current
Right,
policy.
yep. So that action item would be to have that second paragraph added back in on policy 3160.
The
no
no
physical
physical
examinations.
examinations may be required of any employee, right?
Right,
Okay, so unstrike it. and have it stay in.
I should be writing these down, I'm sorry.
That's okay. Well, Lynn is.
When is, okay,
Lynn is definitely writing them all down.
all right.
What about, the part or question that Tina had on the drug test, which is the. What is?
We asked Tina and she was. I also mentioned the clarification that we do have that drug testing in our
Mhm.
existing policy. And it didn't sound like Tina had any objections to leaving the drug testing in the proposed policy. Is
So-
that
No,
accurate?
I'm all-
Tina?
No.
I'm all good. It seems covered.
Okay.
Thank you.
Okay, so we don't have to do anything with the physical examinations portion of this, correct?
Doesn't sound like it.
All right.
Move along.
Lynn, do you have?
So the action item for this one is to unstrike the paragraph that begins with no physical examination may be required.
Okay, thank you.
Right. Following the order, we go back to staff ethics, 3210.
Yep.
This is the only other heavy hitter that I kind of identified, that, you know, like, we went from 18 descriptive bullet points and 4112 down to 9. I sort of feel like some of these are a pretty good practice to have in place. I'm just trying to seek an explanation as to why we're going down from why the change, I guess.
So, in this one, and if you, recall, when we first brought this, group one to you guys.
Yeah.
We shared that many of these were more, standard issue and have had a lot of changes in law and everything else. Now, if you want, I can go back to Neola and say, are there reasons in law that you pick these A through I? And I could also give them our list and say, would any of these be problematic? And then give you a report back. Cause we just went with this one because we were like. We thought, okay, Neola's aren't gonna be problematic. Are some of ours? I don't know.
I guess this would be a
So-
rare instance
Yeah.
where we happen to have a policy that happens to be more detailed than Neola's.
Yeah, so if you want, to have us run that avenue, you know, I can take, both our policies and say, here's what you recommend. I'm seeing these as probably not problematic. Are there ours that are problematic that we shouldn't have, and the rest, we should just add, if they're not problematic, right?
I like
Yeah, I
that
agree.
solution. I don't know if any,
No, I think it's a good idea, just because obviously they got put in there for a reason and,
Yeah,
you know.
And
so
I
if we
don't
can
know- I don't
fix it
know-
Ours too.
yeah,
right?
and I don't know if ours, from a legal standpoint, if any of ours are problematic or not, but I can have them review it. And if they're not, let's add them.
okay.
I mean, does anybody have a problem with this list? I mean, did anybody, when they read through that, said, oh, that's a bad thing, we don't want that?
I don't think that, I don't see how you would argue it into that, yeah.
Okay, so we're okay keeping their list, I'm just asking about our list,
Right.
are any of these problematic for us legally? And if not, let's add them to this list. Yes, no?
Tina? any
I don't,
thoughts?
I mean, I guess I'm just tending to go with Neola because some of our stuff is outdated and, laws and statutes or whatever change. And so I guess I'm just trusting that Neola picked the best ones, I don't know if it's, if we included the other ones, that's fine to ask that, but I guess I just don't feel the need to, relitigate that. Like if they put those in there, there must be a reason.
My only other thought on that is the letter H, adhere to the policies of the board. Looking at our current policy, how many of those fall, that's so blanketed, that's so general. How many of our current ones that are on that list would fall under some of these other ones? Where this is maybe more general, where ours are more specific, and do they maybe go to more general? I don't know, it's just, it's a thought that do some of them fit under some of these
Yeah,
others?
but you could probably make that argument for their list as well.
I'm just saying, if that's why some of them aren't listed, they're keeping it more general instead of super specific.
Okay, so I need direction. What would you like me to do?
First option was option one, where we go back to Neola and ask them if there are any particular items on our existing policy that are problematic and conflicting with theirs. Option two is to basically leave it as is. What are the, it sounds like from Tina's perspective is to leave it as is.
Correct.
The-
Option two.
Option two,
Thank you.
what do you think, David?
I didn't review the past one,
Okay,
so I don't know what 5 we lost or 8 from, if that's.
Yeah, it's,
Yeah. I find that a lot of these things are, what do you say, I don't say gray areas, but there's a lot of ways to be unethical, in which case if you have to find every single one of them, you're trying to be over, what's the right word, over prescriptive. So I'm gonna guess that these 8 that Neola used are adequate. But there's no harm in asking, Craig, so we could certainly ask as you recommended to, you know. I mean,
there's a lot of good ones on here, I'm sorry, just.
sure, but are the blankets of Neola adequately cover the good ones that we had been overly prescriptive on?
Sure.
And because I didn't read the old one, right, so. But it doesn't, there's no harm in asking them, say, can we have these 8 back? Or is there a reason to leave them on? Per your suggestion.
So that would be option one. All right, Lori,
I don't think it would hurt to just make sure that, doesn't mean we have to put them all in there, but I don't think it would hurt just to see if we can keep some of the ones that were on our original, since that's been our trend to try to. So I would be fine with trying to find out if we could keep some or all of them, or,
all right, and then I would also advocate for that first option. That's not obvious already, so if we could go back to Neola and see if there's any problematic ones on there.
okay, so our action item on that one is to,
Check with Neola.
Check
Ours
with-
are problematic or conflicting with theirs, and then see if we can add those to it.
Okay. That wasn't so bad. 3220 is a staff evaluation and effective educator effectiveness, if I'm following the order correctly.
Mhm. Tina had a question on this one, and I can answer it for you. At least from me and below. Yes, our staff who does evaluations goes through training annually. We get that training from CISA 6. John Slender is the person who trains us to stay together. From the board standpoint in their evaluation of me, I know that the planning committee has talked about doing some calibration, and I believe Diana's in discussion a little bit with that. Tony Arnett really kind of did a in brief calibration last year. If you guys remember, he just kind of went over and said, here's kind of the things that we're doing and whatever else. But that's my understanding of it, to answer your question.
For staff evaluation?
Yeah.
Or is that superintendent evaluation?
No, for you guys to do superintendent evaluation,
Oh,
Diana and planning are also going to be working with CISA 6.
okay, okay,
You guys are gonna use the same person that we use administratively when we do administrative evaluations and staff evaluations, we calibrate.
okay, so it is related to the staff evaluation,
Yes.
got it.
Okay, any questions?
Questions, Tina?
Tina, you have any questions on that?
I don't
Okay,
think so.
well-
I'm sorry. I'm trying to follow, I'm trying to go from screen to screen there. Sorry about that.
I, no, I'm with you. I too was going back and forth between the email and the,
I've got
and,
this the Zoom screen and the different, yeah, the email and the things. I had a question. Oh, I don't remember exactly where it was. Maybe it was the second group as far as at K through 6 teachers, the English teachers all having phonics background. I think I had a
oh,
question on
yeah,
that.
yep,
But
of
yes,
course,
you answered
Act
my
20
question as far as
yeah.
superintendent.
Of course, Act 20 is, helping to change that landscape and mandate that, and so that was part of, new Act 20 legislation, and so, yes, we will be moving in that direction. I'm not sure, because I don't, I'm not Jenny, so I'd have to ask her how many of them have phonics, instruction or further training in that phonics programming. So I don't know the answer to that as of now, but I know moving forward what we're going to be doing.
Do you think some of this is because we know we're gonna be,
Yes.
so they've kind of already been starting to make those little changes, you think,
Yes.
in there,
Mhm.
makes sense.
So Tina, do you have any further questions on that?
Nope, all good, thanks.
I did have one quick note. Under licensed teachers and principals. It says evaluation shall be conducted the first year of employment and every third year after, or more frequently. Those 3 words, or more frequently, is an add. I'm not saying that's a bad thing. I think it's probably a good thing. But I just wanted to make the committee aware that that is an addition to from our existing policy.
I mean, I just don't want anybody to think that they only get evaluated every third year. I mean, if we have somebody who's under a plan and we wanna do it more often than that,
I think it's.
We're comfortable with those recommendations. I see some nodding heads and I'm assuming Tina's okay with it as well.
So no action.
No action item. Alrighty,
Go to first read.
yes. 3340 grievance procedures. We had discussed this briefly already. I know I did also have questions about the timeframes. I just wanted to make sure that one, they're a compromise with the staff grievance procedure, so that they're getting the responses that they need in a timely manner, as well as sympathetic to the process, so that was my thought. Go. Any questions on that particular topic? Kind of already covered it.
With the notes, Lynn, how's this gonna run into first read? Are we gonna incorporate the notes into this 3340 with the handwritten notes? Is that, how do we?
That's.
I'm assuming that he's gonna be done by the time we get to the board meeting.
Okay, so we can put that, if Craig, if there's nothing else on it, we can. recommend
If not-
Forward with the handwritten notes, but technically, we won't
With that
even see it
updated.
until we're there on next
Right.
week.
Right,
Mhm.
okay.
Whatever.
Yeah.
The only other question I had, and it's just maybe it says only one subject matter shall be covered in any one grievance. I mean, what does that mean? Does that mean that one particular incident that's covered, or is it are there, because usually when there's a grievance, there's a slew of things
I
that,
would tend to agree. It's not one subject matter, it's one incident,
yeah,
right? Is that what you're getting at?
yeah,
Yeah,
just confused by that.
yeah, so, it's. If you can't say, well, I'm grieving, that, how we have to put timesheets together and whether or not, the decision of the administrator to approve that timesheet. That's one separate item. And then say, I also want to grieve whether or not I can, take my lunch breaks at a certain time or not. And then another, I mean,
Okay.
right, I mean,
Yeah.
those are all separate grievable things.
Right.
Right? You can't lump all things that I care about with, how I get paid, right?
Sure.
And make a grievance out of it, right? We have to grieve each one of those specifically and separately, and the reason they say that is because there are laws that pertain to specific parts of how pay structures are implemented and so on. So that's why they say it has to be one, clear
Yeah.
thing, and then if you have a grievance about some other thing, you can
Issue another one for it.
issue another grievance, right? And we'll go through the process with that one too.
All right, any other questions on that one? Okay, well, moving along to policy 3362.
No, can we go back? We skipped 3230.
Did we?
Did we not? Or did we jump ahead to ethics and conflict of interest?
I'm sorry.
Going down the line.
I was, see, I appreciate you keeping me on my toes.
No, they're
the
small,
bullets,
it's small
they're
font,
different
it's
than the
easy
bottom.
to miss, but
We're,
3230.
It's the bottom of the list.
oh, okay, thank you. All right, ethics and conflict of interest. Personally, I didn't really see much on this, that I had an issue with, except for a spelling mistake. Like that was a Neola spelling mistake, hopefully they catch it. Anybody on this one?
Mhm.
3230 would go ahead and move forward for a recommendation.
3362 is next.
3362 is next. And that is the employee anti-harassment policy.
Can I just, I'm kind of confused on something. So when I was reading, and I know that this is because we've got different policies. So when I look at like our policy, doesn't this also kind of include the student sexual harassment that's right underneath like our HR board it's number, hold on, I can't read my own writing.
This is employee.
I know, but it talks about
Well,
students.
but see, I think.
So that's where I'm getting like, you know what I mean? It talks about inappropriately.
Right, because it's, there can be instances of sexual harassment between employee and student.
Okay,
So,
so it has to, so we still want to keep them separate. And we will still
Absolutely.
have, okay, I'm not saying we shouldn't, that's where I was like, my brain, I think I just looked at way too many policies.
it's
in one
okay.
thing. Now starting to see circles, okay. Cause I know it can get confused, especially like harassment and bully, you've got the staff and you've got the students, so I guess when I looked at our own policies, it made me go, well, wait, I'm seeing this twice, so I just didn't want to be.
Do we don't, we no longer have Tina, I just want to let people know about that.
Yeah, do you have questions on this one?
Is she the phone number or is that someone?
No, she said she was gonna know early.
Her notes on this one were related to the timeframes, which we've
I can.
We covered.
addressed. I did have a question from Diana on this one. Did you?
I don't remember.
Okay,
Did I say, was it this one?
yes.
I know, he's
I-
trying to
I
go
think
over
you're-
yesterday and today.
You're referring to the last sentence of the first paragraph, I believe.
What did it say?
In this day and age, can we still use
yeah.
the words male and female as discussed in page?
Yeah, and I just put that as a note, so based on what we just found from Scott earlier today, that perhaps we let Neola figure that out, and that could be an update. I do have that question, that's real forward thinking, especially in the world.
Paragraph does that relate to?
the
When I
second
talk about
paragraph.
mail,
I would say,
mail to
Craig,
mail.
I would throw the second paragraph in with the first discussion, Craig, and ask them to take a look at this one on the, as maybe Sam said, highlight.
I feel like there's mail
What's
and female in
negotiable,
other
what's not.
policies
Well,
too.
And that's where my note to myself, just before you asked that was, okay, table that one, maybe let Neola figure that out and do some of the updates. Cause there's one in the FMLA one where they use son and daughter as opposed to child. That it's getting forward thinking and, okay, based on again, what Scott said earlier. I guess don't worry about that language right now, let them figure that out with an update down the road.
So I guess I would be seeking direction from the committee, considering we don't want to have a whole bunch of them coming back to us.
But that's where Neola, if they decide to make that change where they don't want to use male and female, that would come through their updates.
I
not
see
us
what you're
having to
saying.
look at.
Right.
So that's why I'm saying, let Neola, based on what we just learned now, let Neola figure that out. And then that'll be one of their twice a year update kinds of things that they would do.
Okay,
Don't male and female refer to biological sex? So I think that regardless of gender questions, I think that male and female are, I mean, I think that's really a different thing, right? I'm not saying that, maybe you want to address the fact that regardless of a person's gender orientation, they can commit or receive harassment. That's worthwhile to discuss, but
I guess I don't really want to get too far off in the weeds on this part of the discussion.
Yeah.
Because I think that the spirit of this particular paragraph is conveying that harassment can occur between different individuals.
yeah,
And
regardless of the
yes,
particulars, yeah.
Okay.
So we're letting that sit.
I'm good with letting it sit.
no, I
Dave?
think,
So anything else besides timelines that, we
no,
need to input? We'll input the timelines in this one, as per the other policies.
that's what I gathered so far.
Okay.
So, all right, let's move on. The next one on our list is the FMLA policy, which, if I'm not mistaken, ours is pretty much like non-existent. But it basically says something to the effect of, yeah, it would comply with the
We'll comply
law.
with the law, yeah, that's it.
So,
Yeah, there you go.
I didn't, and basically this elaborates on what the law is, so I don't see any problem.
Margaret, you're, muted if you're trying to talk.
Well, I would just say that there's a lot of language that is missing from our current policy that since it was last written, really needs to be incorporated. And in order for us to provide like updated communication to employees, we need to be able to rely on a policy that is reflective of that. And I mean, like notices of rights and responsibilities and the language associated with that. A lot of and I get it's a lot of legal jargon and tons of extra words, but I mean, if that's what the FMLA has determined satisfies compliance, like our current policy and our current forms are, not really fully complying with the changes that have been occurring in FMLA as it gets put more and more into practice.
All right,
I would welcome the Neola one from a practice standpoint because it provides solid background upon which to like communicate out to employees and to demonstrate the district's compliance with FMLA.
any objections to the FMLA policy as recommended moving forward? All right. That'll be a recommendation from the committee. Moving on to section group 2, item D on the agenda. It looks like employment of professional staff. My notes are, well, there's a paragraph that's discussing on page 2. Any person that signs a contract to teach in the district must. And it was changed from, within 10 days after signing contract filed in the office, statement showing their. Certificate of license. I sort of think that maybe there should be some sort of a, timeline on that, cause
We just want you to know that as a school district, we don't rely on them to do it within a time period. We just go to the DPI licensing
okay,
portal and we see if they're licensed or not. So that's our practice and what we've been doing. We can certainly require it if you want, but it just makes an extra step on the employee where it's relatively easy information for us to verify.
thank you for clarifying
Yep.
that. The only other thing that, that I noticed about this particular policy, that's this whole, section regarding, points with a, professional that, would be experience-based licensure for technical and vocational
Yeah,
education.
that's out of the law.
That, okay, and that's a good thing that we're able to clarify that too, so. At least I thought so.
Mhm.
Any objections to policy 3120 moving forward for recommendation? All right, let's do that. The next one on the list is 3120.04, employment of substitutes. Seems very straightforward as well. Any objections to 3120.04 moving forward?
No, not a noun specific, Craig, but I'm just gonna say, Jared and Lynn, if there were ones that they were significantly different from our existing policies, I mean, I see something that, let's say, for example, the 29 days of consecutive employment, et cetera. Is that consistent? Is that new? Does that cause you pause? From our perspective, if we're not familiar entirely with the old policy or or how that's implemented in practice, I assume you're raising the flag on things that are new or
Yes.
different.
Mhm.
Okay, I just wanted to
Mhm.
trust you on those things, because no, I can't verify
if-
every single one of them, because that's what you guys are doing, not.
Yeah, Margaret.
So
kinda
Margaret will
helped us
tell
with
you here.
these,
Yeah,
So the 29 days is driven by the requirements for DPI and what they view as a
Yeah.
short-term substitute assignment. So, and we are required to comply with that, time period. And then the half day is just simply like a reflection of how we pay people. So we don't pay substitutes that are teachers on it, well, we don't pay any substitutes on an hourly basis, we pay them on half or whole days, so that's where those like timelines and the specifics are coming from.
And I will again share with you, if it has a yellow highlight, that's verbiage that we changed. Right?
oh, great,
So, if you see it there
okay.
and you
that's-
don't know why we changed it, you can ask the question and we should be able to answer that for you.
No, I just
Okay.
want, I assume that was the case. We talked about the ground rules of how we're gonna be looking at this. When we started 9 months ago, I just wanted to make sure that that was still the case, that these are the ones that we're merging and or carrying,
Right.
what do we call it?
So
Transferring
like,
from one to the other that are more or less the same.
so like on the 29th day, we happen to use the DPI statutory date,
Yeah.
but some districts do fewer.
Oh, okay.
And so they would put in their date, at which they become, okay?
No problem with moving forward with that one, I
Can I
think.
ask a clarifying question?
Go ahead.
please? The last acknowledged bullet point on page 1, where it talks about relatives of staff members, we're talking purely about subs here. So please clarify, does that mean that if I'm the principal in a building, my brother, sister, cousin, niece, nephew, relative cannot be a substitute in that building because they are directly being supervised? That's how I'm reading that, and I'm wondering if that's really what we wanted to say.
So that reflects the current practice, which is if you're a relative, you're not supervised by that relative. And we designate an alternate person as the relative. And we have a few situations like that currently in the district.
Yep, I understand that with staff members, but this policy is specific for substitutes. So we're saying on that given day, if that substitute is needed at my building, RMS or whatever it is, someone else would be supervising them that day?
We,
And they
we
can
would
say,
designate another person, so we do it on a
I just
case
wanted to
by,
make sure, just so.
Yeah,
Yeah.
because we don't
You
wanna
wanna
tell a sub,
subs,
you can't
Yeah,
sub in
either-
this
right,
building.
right,
So
we
we
need
figure,
sub- I just wanted to make sure there wasn't a hiccup in that, okay.
Okay. Sounds good. We're all good with that one then? All right. Next on the list is the job sharing policy, which I don't know that I've seen this one before in our existing policy. But it definitely sounds kind of unique, and I didn't have any objection to it. Anybody else?
I have a question in there.
Yeah.
There currently is not verbiage regarding benefits. Does that mean that with job sharing, because typically if you have one position, there's benefits for that. In other districts, if it's a shared half 50-50, there's 50-50 benefits. Are we saying by not having any verbiage in there about benefits, that if you job share, you have no benefits offered?
I don't know if there's 50-50 benefits anymore in district.
It may have changed, yeah.
I mean, Margaret, you can talk to that. I don't know if
Right.
that's allowable anymore.
so, I mean, we have job sharing arrangements where the total benefit package is equal to one FTE or one person working full-time. And we do have contract language from dating back to before I started working at the district that specifies job sharing arrangements will not result in the addition of benefits. So from a practice standpoint, the district has gone to partners that are job sharing and asked, how do you intend to divide this is a benefit pot for both of you, which is equal to one full-time one full-time person. How do you intend to divide the benefits? And I will say that, I mean, most of the time, they already have a plan before they even get to my office, but that is a practice. So, this would just be basically saying that they're allowed to share one full-time position, which is interpreted as like one person and one FTE, and whatever comes with that type of employment arrangement.
So,
Because it says position.
right, with, to piggyback on Diana's question, would we want to have some sort of language in there that would potentially clarify how one would go about that process of, identifying those benefits?
No, because if our process changes, then we're gonna have to come back every time and it may change based on whatever the job share looks like.
Yeah.
Well, right,
know.
but shouldn't it mention something about like this should be handled, those
I don't know. how
questions of benefits would be handled through the HR and the superintendent, or something of that nature. I don't know.
Margaret, what are your thoughts on that?
Well, I mean, we take job sharing requests in all sorts of forms, and we've done where people come together as pairs and requested, or we have situations where an individual has requested, and then we've conducted a recruitment effort to find a partner for that person. I mean, I don't oppose adding more procedural language. In the documents that I have in terms of the contract documents, it does very specifically say that, job shares are approved at the discretion of the district. And taken into account like the needs of the buildings and needs of the students and other, district related considerations, but I don't have any objection to adding language that would specify,
Would
job.
add just that
request.
language, I mean, yeah, I would say the only thing, and I don't know if it strengthens this. Adding that language from the contract, would be about the only way I think we could do this, because. you have so many different kinds of requests coming to you. I don't know how we would codify in language, procedural language that would bring every possible request that you have come to you.
Right,
But the fact of the matter is, it should probably specify that any additional requests should be made to somebody, right?
I mean, we could add that any request be, made through the HR office if you want.
I don't know, maybe we're splitting hairs, I don't know. Thoughts?
I don't know that. Up to
I
you.
mean, I'm just wondering if that wouldn't be more appropriately placed in the handbook. You know, it's pulled off of the policy and then the policy in the handbook language then directs or informs the staff on how to initiate that process.
That's a good idea.
Okay.
It could be more open there and easier changed.
Fair enough, makes sense.
Yeah, I'm fine with just having what we have.
All right, then I guess, hearing no objections to that policy. It moves forward for first read as well, the job sharing. All right, the next one on the list is, criminal history record check and employee self-reporting requirements.
So you can see that ours had extensively more language than theirs that we recommended pulling in from ours.
Yeah.
I think this is, maybe this is just me, but I think that in the bit that you added on the first page, you got the same paragraph repeated twice.
Yeah, I'm seeing that too.
Oh, yeah.
Oh. We may have that,
Typo or whatever.
yeah, that's my fault. I was the clerical on that. I apologize. I can't believe that's the only thing that we caught so far.
We could have gotten this a little bit better.
Yeah, we haven't gotten through all of them yet, but, I apologize, I did that.
Yeah.
Let's be, so, we help,
Double
strike that one.
second repeated paragraph.
Thank you for the catch. My apologies.
That'll come up later in the month.
Monday. Monday.
Really close.
Boy, if that's something that's gotta come up, then I'm really in trouble.
Appreciate the members of the board for not having a 20-minute discussion on whether we should strike the first or the second.
Put that in notes.
Yeah, do we wanna strike the first one or the second one? Let's talk about this.
We should strike the second half of the first paragraph and the first half of the second paragraph.
Oh my God.
Oh, geez.
Did I mention it was my anniversary?
Yes.
Okay, I just wanted to, you know,
Is the error?
like, before she goes to bed, I'd like to say, honey, I love you. That's the only one that's all I.
Yeah, look at our watch, so.
Oh,
All right,
Use that top one and X9.
so, okay, the next one we got is a drug-free workplace, policy 3122.01. I know we had some questions on this. On the last paragraph of this particular policy, not the second to last paragraph on.
on the social media part?
Yeah, well, I mean, you have that whole section stricken, disciplinary action may result if a staff member conduct involves the depiction of staff members engaging in use of alcohol or drugs, social media or other outlets in a fashion that tends to provoke public scrutiny, damage staff members' credibility, depict inappropriate involvement of minors, or in some fashion diminish the staff member's ability to safely and effectively perform his or her duties. If the district administration becomes aware of such circumstances, it will investigate the matter, even though the events occurred on one's personal time and not on district property or at a district event.
So I would be comfortable with, removing the strike through. But I would like to work with our attorney about adding, language in there about a nexus to their employment. Because there are things that our staff do, teachers, employees of any kind, right? They may be having a good time, they put it on their personal social page, and that's meant for them and their personal time. I don't wanna have to investigate every time a parent or somebody else sees something that they think is inappropriate because they're a teacher or whatever.
Isn't that in the first
Right.
sentence?
It is, but that's why I was like, why do we have this in here? We can investigate anything that's a nexus to employment. A drunken driving or whatever else, why do we have to call out social media? We're gonna investigate it if it's a nexus to employment. I don't wanna investigate every charge that comes by, and this seems to me to tell me that I have to investigate every charge that comes by. That's why we struck it.
Oh,
No, go-
no, you guys go first. I think I was.
I was just gonna say, I have friends, family who are attorneys for organizations who have had to fire employees due to their posts on social media unrelated to actually being at work. And then it resulted in a lawsuit where the discharged employee sued the university that they got discharged from. Because they said, well, you never said that was in my employment contract, that I couldn't complain about this while I was off time, but at work. In which case, that's not necessarily drug and alcohol, but they were complaining on social media. It resulted in a lawsuit as to how far do the bounds of employment extend in the world of social media.
Yeah.
If it's not in this policy, Jared, I would encourage us to make sure that it's in a policy and well reviewed by legal. Because that is that is a landmine to step on. Is that if
The
we
dean
find
in
out-
lacrosse at
or
UW
the,
lacrosse.
Yeah.
the, what's his, whoever that was in.
I mean, this
lacrosse.
speaks
The,
right to that kind of stuff.
The dean, thank you, the
Yeah.
dean, exactly, because he's probably suing lacrosse for.
Oh, he already
Yeah,
did.
Exactly,
Yeah.
for unlawful discharge, because you never said I couldn't do that. And so if you put it in there, you better be sure that you can do it.
And I know, I was just gonna
That's
say,
why
we do have the social media policy, I don't know when that, if that's gonna be coming soon,
That
but
was for the students or was that for the?
there's a staff, there's
There's
one in
that.
HR. So I think that will cover, and I think that mainly is, to not be,
Well,
That's during work hours.
it's
This-
not
this is
about what
outside of
they're
work
doing,
hours.
right.
And
This
again,
isn't the drug
if
and
there's a
alcohol
nexus.
policy.
That's
you
what
can
I'm saying, like,
investigate it.
this is drug and alcohol, that's more of, you don't wanna be,
I think Jared's right on
guess
where he says,
we'll
just double check
visit
what
or
is applicable and what's not, what should be put back in here before you strike it.
And I would,
I mean,
I would just add that we're using language in here like tends to, that, damages their their credibility, tends to provoke scrutiny. We're kind of wishy-washy with the language on this. If you're going to have this in there, it needs to be specific to what you can do because, well, to the guy in lacrosse, hey, look, I did this my own time. We're, consenting adults. There's nothing here. I like having it stricken where that first paragraph, where you have the nexus to the staff member's role, leaves it open to our interpretation. And, Jared can do that. If you feel that that tied our hands, then consulting with a lawyer would probably be the best choice.
that's what I was just gonna say, so I mean. I'm assuming it's legal because it's in here, but at the same time, it may be like that.
I'll kick it back to Noel.
And my assumption is that it's not a necessity because it's one of those parenthesis optional items
Mhm.
to choose from. So therefore, there wouldn't be the
That's-
strong.
that's
legal
why-
guidance
That's why I left a little bit of it,
behind it.
but
Yeah, like,
cause I could have said, oh, we could have just taken out off work conduct and not talked about off work conduct. I just took off the part that I thought was,
That still gives enough basis to give us a blanket.
I mean, I want you guys to be aware, like, if there's a social media thing out there that I believe has a nexus to the job, you bet we're gonna investigate it,
right,
right? I just don't want anybody out there saying, well, it says you're investigating this and now I have to investigate every buyer, what? I pretend Margaret will be having to investigate.
and my comment, Jared, is
Yeah.
not so much to social media and other things related to the job, nexus to the job, in or out. I'm saying is that let's make sure that this is in the Name of the policy, just to make sure I got it right.
This is, yeah, this is the,
This is a drug-free workplace.
Yeah,
Okay.
we're talking about drugs and alcohol.
There you go.
Yeah.
Okay, so if there needs to be a blanket statement regarding, called moral behavior outside of work, I don't care whatever box you want to put it in. It could belong somewhere, but it doesn't seem like it belongs here. That's my comment. And so I would strike it only to get it out of here because nobody's ever gonna look for it here. But then put it somewhere else where it may be more appropriate and properly reviewed.
I guess I'm still torn. I still think that it wouldn't hurt anything to have it there, just,
True, just make sure it's somewhere else too, so if I'm not
Yeah.
looking at, hey, can I do what the dean did in lacrosse? And then I gotta find the drug-free workplace policy.
right.
Well, and it
Yeah,
can't,
and this is specifically in regards to alcohol and drugs, it says in the struck out section, so maybe
Right.
having a broader statement.
That's
about,
my
like,
comment
It's
is
within,
saying,
it's within the purview of the district.
let's
to
get it
investigate those
somewhere.
things.
Yeah.
It may not belong here, but it could be duplicated here, I just wanna make sure it's somewhere else, if we're gonna review it, make sure we review it across the board.
Specificity cuts both ways.
Yes.
It covers you that, hey, look, we're pointing this specifically out to you, but it also says, this is your specificity, I was over here, so this can't touch me. By being general, we got a broader brush we can swing with.
No, and I guess in that respect, I guess I would like to defer to, the legal thought on that, you know?
Okay, so, what's the direction?
To get some, oh boy, are we,
We have going with Neola right now, just that very first one, that's the only one we're double back and, those, the addition of those 8 items. Or those additional of the
yep,
ethics lists.
I think this one, though, this one would be more of a local attorney discussion.
Okay.
Instead of a Neola discussion. I mean, if we don't have a problem with the policy, we have a problem with, do we want to enact this choice or not?
Right.
In our local situation. Right,
The only thing I will say there is, if you're paying Neola for this service, we send this back to them to get their feeling on the changes we want to enact, that's part of the service. We go to our local attorney, we're going to get charged for
Right.
that. And that if we're going to do that, this has to be brought to the board, as we want to take this to the local attorney, because the committees cannot
Good point.
use, administrative funds or services like this. I'm blanking on the actual term. You would have to refer it to the committees that I have to, I want to do this unless that's underneath you have a fund within the power of the superintendent that you can tap into for this. Otherwise,
Yeah,
it's
so-
Board directive, it has to come
Yeah.
from the full board.
so. We wouldn't be using any additional legal fees outside of the ones we have budgeted, if that's what you're talking about.
Yeah, and then.
I think that would have to go to full board for approval.
Right.
For additional funds.
Yep.
Right, if it's
And I didn't
using
know if
funds
the-
that we already have
If you
budgeted.
get them on retainer and this falls within under that, that's fine. But if every time we send a policy to them, Dan's gonna ding us for $200. We have to get board approval.
well, hold on a second, because prior to Neola, the policy committee would have policies reviewed by legal all the time.
Right.
That's what I'm saying. What Jared's
Yeah.
clarifying is, we have a retainer for the attorney that we can use this for.
Sure.
What I'm asking is that if we're gonna do this, is it outside the bounds of that? If it's outside the bounds of that and we're getting extra funds.
I don't believe that this would require us to go to the full board for extra funds. Earmarked specifically for
that we're-
this project.
Nope, that falls within what we're doing, then we're good.
All right. But it's valuable knowledge to know, so. So we're clear on the action items on that specific one. Are we seeking some specific, guidance on that particular language, or are we just going to basically, I'm a little unclear on that myself, sorry.
That's why I asked,
Yeah.
what was it that you want me to do? I put the recommendation out there that we strike it. Is is your conversation asking me to go back to our attorney and say codify Jared's response or not? Or what were you asking me to do?
So,
That's right, I mean, my suggestion would be is just double check that that's reasonable to strike it, that it doesn't materially affect the intent of the paragraph.
Okay. That's,
that's one.
Yeah, and I'm not saying this is a committee, I'm
Right.
just,
I'm looking at it like, that if we do take it on, I mean, it doesn't seem like it puts us into a lot of extra liability. Yeah, it's the specificity of the statement. I do find value in finding some clarification on that. That, is it too specific that, it allows an exception for other activity? You
okay,
know?
so my question is this. It sounds like you were asking me to ask them to make a determination on whether or not they think it's appropriate for us to strike this or not, and what are the positive and negatives of striking it. Is that right?
Somewhat, yes.
Is there something else that I need to do outside of those two?
That, is it too specific? This specific question, is it too specific that it opens the door for an exception to other activity that we're trying to prevent through the policy?
What other activity? I guess I'm confused.
Yeah, I'm confused.
Illicit drug use and or alcohol use,
Okay,
basically.
so just the drug and alcohol. Okay, I didn't know if you were going on other things.
So say that again,
Yeah.
the question you want me to ask? Like if I were the attorney and you wanted to ask me the question, what would you ask me? No,
Let's play roles.
Well, that's why I said, cause I have to ask them and I wanna make sure I ask them the right thing.
No, I know.
Sorry,
Would you just want, you're talking about, you know.
I'm actually trying to clarify what you're asking too, so.
Yeah,
Yeah.
so it's, whether or not they approve the striking, positive or negatives of leaving it and leaving it out. And, any recommended language if we were to add additional language,
Okay. Good enough for me.
something like that.
Okay,
And they make a.
You have all three of those?
Yeah. I mean, that's
So-
what wrote it.
All right, let's say that one more time, Fred,
Yeah.
because
So,
I'm trying to write a list.
so I would, and again, I'm gonna defer to the committee here, but, whether or not we should strike it or not. The positives and the negatives of striking it or leaving it in, and any recommended language.
any other recommended
Any other
language?
recommended language, if not, what's
Okay.
included.
Okay,
I mean, I think it's also knowing what we've what we're trying to get out of it, leaving that first line like you did. If that maybe gives us the, you know what I mean? Does that give us the opportunity to do what we struck out? Am I saying that right? Without actually saying it,
right,
because that may be more efficient for the district.
okay,
It seemed like that's,
I think I
You
got,
good with that? Fred? Is that-
I'm clear
okay.
with it.
Okay.
all right.
No, it's more than mud, I'm clear.
Murky
You,
mud.
if you keep talking, it might get muddy, but right now I'm clear.
It's starting to get clearer.
When I go back to the notes, I hope it's as clear.
Well, I highlighted the questions
I
now
know.
around all my notes that I kept writing everybody's questions.
Oh.
It's
Thank
okay.
you for bearing with us. We're still almost there.
I love it.
Uh,
What's the next
Now I
one?
gotta find my.
The next one is 3132 vacancies.
Yeah,
Oh,
so we didn't have a vacancies policy. This would be you know. Margaret suggests that we have one. I believe that's right, Margaret, isn't that? She there?
I think it's a good idea for us to specify a vacancy policy, yes.
This is
And I
what we-
think that it should be clear that we're gonna establish policies and or procedures that are related to the policy. And that it will select the person that the district will select the person that's most qualified to do the job.
Well,
I mean, this is
America-
all stuff that we are I guess the best way to say it, we're currently doing this.
So
I mean, this-
Merit based selection process is what this policy is stating.
And not doing an internal. We don't do that, I'm assuming, first,
Well,
or do we?
Well, I mean, an internal candidate can still
Right.
be the best person suited to perform that duty.
Oh, yeah,
So
no, I
I-
know,
yeah.
but when we cross, I was just wondering what the, do those look very different? So the first one, whenever possible, vacant positions shall be posted internally for a period of blank days before being posted. So we aren't doing that. Is that what Margaret's saying? So this
So,
isn't.
no,
changing our
well, no, I
protocol.
wouldn't,
Okay,
I wouldn't say that, except that I would say that we do not necessarily always abide by a specific time frame for a posting, and the language in this says vacant positions shall be posted internally, which is, pretty strong language in terms of requiring us. We do post all of our positions. I mean, that I can tell you, we post every job that is available. But the actual timeline will vary based upon the circumstances of that particular recruitment. And sometimes, for example, we'll post a job internally for 3 days. Sometimes we'll post it continuously. I mean, it really is dependent upon the position and the labor market. But I can say that we consistently post all positions internally through the email system right now. So it's not that we don't do this. It was just that this language is like locking us into a certain time frame that we currently have more latitude to work with based on the situation.
Anybody opposed to this particular policy or moving forward as recommended?
Sorry.
You
Go-
go
no,
ahead.
you go
No,
first.
go
I
ahead,
think-
please.
No, you spoke before me, please.
No,
Go ahead,
I
Diane.
I don't care.
Go ahead.
Just somebody go.
Okay, I'll
Thank
go.
you.
So 2 questions. Number 1. If second paragraph says that it's in accordance with established procedures. There are candidates out there that look to see postings and they'll go to board policy to see, is this internally posted, not? So if it's established procedures, where are those located? Is that an administrative guideline? Is that in a handbook somewhere? Is that in someone's mind somewhere? Where would that be? And if we don't have that, where could, it's not a discussion for today, but it should be somewhere. And secondly, if we do post things internally prior to externally, then I would hope that there would be language in here, but get rid of the strong language.
Oh, but to
Says it
clarify,
shall-
we don't post in advance of posting externally. I mean, there are times where,
Okay, then I misunderstood you, because it was, yeah, okay.
Yeah,
okay,
no,
then
I
it's-
mean,
yeah.
sometimes we'll post internal only. Sometimes we'll post internal and external concurrently, but we don't have a practice of doing advance notice of consistently doing advance notice of internal to internal potential applicants.
But you still have the question on where the established procedures are contained. Just wanted to capture that.
Thank you.
Okay.
And then, the only thing that I was gonna mention is, I think it would be useful to clarify on the first sentence and the last sentence of the policy. Kind of in keeping with non-discrimination policies, it would be useful to put on the end on the basis of merit of the first sentence and the last sentence. So it would read, it shall be the policy of the board to employ the person best suited to perform the duties of a particular WUSD vacancy at any level on the basis of merit. And then the superintendent shall establish procedures to facilitate, et cetera, the evaluation of these things on the basis of merit. To clarify that best suited is speaking about on the basis of merit, on the basis of ability to effectively perform whatever task it is.
I don't have any objection to that. Either way, I think it seems to clarify it as it is, but I mean, if that helps to be more specific, I don't have an objection to it.
Does merit imply that, like a veteran status? I'm just thinking of, I've been doing something for a while. There's merit versus someone who's new to it, but they have an advanced skill in something.
I think that merit kind of, so I would say that it has to do with aptitude, which is natural ability, but I think that, let's look at the definition on.
And I'm just thinking that in terms of like a merit-based award.
Right.
Yeah, well, I think that merit is I think it kind of gets used in different ways. So Merriam-Webster defines as praiseworthy quality, deserving of esteem. Yeah, it means indicating aptitude, I would say. Maybe you could use a different word for it. I don't know, I feel like merit's just generally the word that they use to describe the ability or excellence in ability to perform a task.
Yeah, since Sam, I love meritocracies, so sign me up. Question is, do we do anything off of seniority? And if we do anything off of seniority, maybe that's the component of merit that they're getting promoted on, or maybe that's just something that we just want to steer clear from. We're not strictly union, we're not strictly, hey, you got your 20 years in before you get promoted to the next rank, et cetera, et cetera. But I would prefer the entire world to be meritocracy, but it's not. And depending on how we currently operate, what our procedures are, I don't really have a lot of energy to put it in or take it out. I just want to make sure that it's not going to put us in a position that we're now saying we're doing something that we haven't historically done and we're not prepared to change the way we've been doing it. So that's.
So maybe clarify whether or not that is the case. and
Exactly,
whether there's other
yeah.
stuff going
Well,
on. Sure.
I guess we can ask, Margaret. I mean, it sounds
Yeah.
like that's our current practice
So-
anyway.
Well, I mean, the language that we use is that we hire the person that best meets the needs of the district. I don't know if the term merit would obligate us to using other criteria, and the person that best meets the hiring needs of the district is quite vague and allows for the ability to take into account a lot of different factors, right? And I mean, that is usually done by design to give the maximum amount of flexibility to the district in making its hiring decisions. I would say from a matter of practice, we of course look for the person whose qualifications best meet our needs. I don't know if that equals the definition of merit-based hiring. So I just don't know if it obligates us into some type of situation. I mean, I don't have any like opposition to the idea. It's just, I'm not real sure from the legal standpoint, if that then puts us in a position where we have to demonstrate certain things that.
Merit checklist.
That was my concern, not to say that it would underpin, but you say it, you have to validate it.
I see. I mean, personally, I think it's fine as it is. And I don't know if I want to mess with it too much. If it necessitates, a review later on, I think that we could certainly do that as a board.
I support that, Craig.
All right,
I appreciate though, that idea.
I do
That's
appreciate the discussion.
definitely something we all have in the front of our mind, but
Just to clarify that, like, the primary thing we should be concerned with is finding the person who can do the best job of
Right.
doing their job.
right. And I think that's one of those things that we have to kind of trust that that's how everyone is.
I think that our district is doing the
Yeah.
best job at
I like yellow.
selecting the best quality candidate that they can. I don't see that we're having a problem with this particular policy at this time. So I think the consensus of our committee at least is to move forward with this as at the first read.
Next one is staff gifts, is that right?
Staff gifts, yeah, I'm sorry.
That's okay, I was just asking because I can get lost in that conversations.
Yeah. The only thing I don't, I'm like, I get a little bit resistant to hung up when it says that, staff gifts are an undesirable practice. I sit back and I'm looking at it like, well, shoot. What do we do, for a family that wants to thank, you know, a teacher, show some teacher appreciation in some respect? Is there another outlet by which they can participate to share their appreciation with a particular teacher? That doesn't involve, you know, embarrassing students with limited means. I guess that would be my question.
Yeah, I could have easily taken out this first little paragraph. You know, I don't know that we need that. You can see that below, our strikeouts indicate that we don't think that, way, matter of fact, as a culture. We're a giving culture here in Watertown, you know.
It says nominal value,
Right,
whether it be a coffee mug or a gift certificate for a coffee or a
couple car washes.
couple car washes.
Yeah.
I mean, nominal is vague, but.
Yeah, that's what I was just gonna say. I
It's
mean, I guess
intentionally
it's
vague.
there to be there, but yeah, we know that, of course. I mean, especially, like, I look at
I mean,
sports.
don't fly anywhere.
The whole
Fly.
team will chip in
Right.
together sometimes to buy a coach, and it's a pretty nice gift when
Yeah,
you've got a
but
whole team.
it's nominal compared to everyone who contributed.
Sometimes.
You know,
Sure, we'll go with that.
I guess I
I know what you're saying. I just, yeah.
I look at
I
I look at
know.
that first paragraph and I kind of cringe because it's like,
Mhm.
it almost discourages sharing, you know,
Appreciation.
appreciation to our teachers and I,
Jared, you said you could have struck the first paragraph, and just started with the based on the, well.
Based on
premise
for-
is the
yeah.
Policy of the board that professional staff members may accept gifts of nominal values from students or parents. And skip the
Well,
first paragraph.
you could just add the word considerable to the first paragraph.
Yeah, excessive or considered, yeah.
And presentation of considerable gifts.
I don't have it, I think it's fine.
I think- yeah.
Craig, but at the same time, it doesn't hurt getting rid of it either, so
right, I'm partial
I'm
on that.
indifferent on
Does it add any value? Or
it.
is it just as good by, it is the policy of the board, blah, blah, blah?
They're both the same to me. Although it does,
So
you're right, if you leave it in, it does give a
So
little bit of a hint of, maybe you shouldn't because it could embarrass somebody.
Is that the message that we want to get across?
What's our policy now? Do we have one?
Yeah, we do. I don't have the exact,
Cautionary tales in it?
I don't have the.
I couldn't cross-reference
The
them.
cross-reference one. On me, I have to go back to my folder. We do have a staff gifts policy, and that's where the highlighted came from.
Sure.
And we pulled it out of our current policy.
I'm just thinking about elementary teachers get gifts at Christmas and Easter, teacher appreciation week, whatever. Sometimes middle school, once in a while for certain teachers at the high school. And I know that we want to be conscientious of those that struggle from that socioeconomic piece. I'm just not sure that we need to state it here because we do say it may, you know,
Right,
they may.
I would like someone providing, a substantial gift to a teacher, irregardless of the impact. on
4140.
The student. It is impractical to be giving someone that just from the fact of career favor. taking the piece out about, he's gonna make someone feel bad because they can't chip in on this.
Mhm.
We should not be accepting gifts.
David, our current is 4140.
It gets hard
Yeah,
because that was
policy
not.
manual,
what it was.
4140.
Well, we do specify.
Yeah,
that.
don't be in draft policies.
But when you say
Oh,
acceptance.
you remember.
Yeah, well, and I think part of this too is I think maybe the word shouldn't be the presentation of gifts, but the acceptance of them. That, I mean, my business has a policy against, I can't accept, gifts from vendors and other people of a certain level.
That's what we have to.
We can't do that. I don't. I
Well-
would say that it's not the presentation that's the problem, it's the acceptance.
I mean, really, the reason that a lot of companies have policies about things like that is because it opens the door for a lot of ambiguous situations with potentials for like abuse and things like that. Unfortunately, that's the reality, is you can't always guarantee.
And I think we have the same thing here because you have teachers who were on scholarship committees and things like
Yeah.
that, so.
Yeah.
The best gifts were personal cards anyway,
Mhm.
with personal
I know,
messages.
that's like-
For real,
I'm torn on this one, because it almost seems like our existing policy is a little bit more specific on this one.
Existing policies, very long sentences. Wait a minute, let me take.
Well, the good news is this one doesn't have a legal background, so there is the ability to change.
The legal background is nominal gift.
Right.
I mean, that's it.
So-
I mean, you have to have the words nominal gift.
Yep.
Right, and just a couple other things just to consider in your decision making. One is that, like, if we don't have that nominal gift value, it then triggers the conversation of, well, at what amount is conflict of interest? Does it become a conflict of interest? And then the second thing is, just from a payroll perspective, at what point are we going to require reporting of more than nominal gifts as a form of essentially tipping, which is a form of compensation that then, requires us to,
I don't think there's an objection to the nominal gift part of the discussion. So, I think it's, whether or not we leave that first paragraph in as is, or if we remove some language of that first paragraph, or if we just remove it altogether.
I liked a lot what Fred said about, defining what part is something that we think might be a little distasteful, which I think you used the word considerable. Right, that, considers the presentation of considerable gifts to professional staff members by students and their parents, an undesirable practice.
Yeah, I don't really like how it says because it tends to embarrass students with limited means, like
We-
that's
we can
kind of
take that
calling
part
them
out.
out.
Yeah.
You know what?
Yeah. I
That's
think
like in their face.
Yeah.
So if we use the first part and we use the word considerable in the word to identify the gift,
You can't use
And
the
we-
word considerable with considers. In the same part of the sentence, that's a language arts.
that's right. So what
Significant
other,
gifts,
She was one of them,
Gifts.
but considers.
what,
Extravagant gifts.
excessive? I just, my brain is getting fried just like everybody else's, I could tell.
Yeah, right, Robin?
but either way, are we clear that we want to take out the verbiage about tends to embarrass students and limits the means?
Yeah, what I would kind of recommend is if you go back to 4140.
I mean,
Sorry, 4140, last sentence, second paragraph, right after the part that you inserted. Which is more or less gifts of a nominal or insubstantial value or service offered for a reason unrelated to employees, would be considered reasonable. And then the very last sentence, larger gifts to employees as individual and largely gifts to employees as an individual, and gifts of more than nominal or insignificant value should be graciously declined. That's our current policy.
Yeah.
Mhm.
In which case, if you struck the first paragraph, Jared, which is the one that is making people feel uncomfortable, and just reinsert the part from our 4140 that says larger gifts to employees as an individual and gifts of more than nominal or insignificant value should be graciously declined, captures, I think, what Fred was
And that's
saying.
saying should be, it's not saying they must.
Yeah, and it
It's
doesn't,
not
it
giving
gets
any
rid of the
kind of-
entire,
yeah.
hey, we're not doing this to embarrass you, we're doing it to prevent the conflict of interest that Sam stated.
Right.
And
Exactly.
which is really what we're after. which is
Exactly.
You can't buy your grade and you can't buy it to buy your product.
Right, that's right.
People, okay, I'm good with that
If you do
change as
that,
well.
Is
you'd
that-
actually eliminate the second paragraph too, because it's redundant based on inserting.
Read.
I don't know.
In 31 and 3214,
Yep.
if you go with David's suggestion.
Yep.
Paragraphs 1 and 2 can both be stricken because it's already talking about nominal gifts being allowed to be accepted, blah, blah, blah.
I don't know which paragraph two you're talking about.
Based on the foregoing premise, it's the policy of the board that professional staff members may accept gifts of nominal value from students or parents.
And then that's where I was gonna right up that insert.
But what you
oh.
stated already captures that.
Yeah.
So it's
So we really
Yes.
just need
that
that
in
literally.
from
right,
our current
that's it.
policy.
Yep.
Neola paragraphs 1 and 2 don't need to be there.
Agreed.
Mhm.
Got it.
Go ahead, Dan.
Do we want to add language about gifts from teachers to students?
I think it's in there.
Well,
Isn't
from
it?
teachers to students, don't think that'd be a different policy.
No, but that was in the. oh,
Yeah,
shoot, I
in
thought I-
Neola's it is, we crossed it off, it says individual gifts from professional staff members to each student are strongly discouraged. We took that out, and the reason I said, I mean, like. Our staff members give nominal gifts to our
Right.
students
at
That could be-
Christmas time.
all the
Yeah.
time,
Yeah,
Yeah.
well,
you know? I mean, that
Right.
that can be like,
think it's-
anybody who did this, you're gonna get that, I mean, that's
Pizza
a
party,
gift
yeah.
thing, right? Pizza
Yeah.
party because you did, I mean, it's part of our PBIS,
Yeah, I don't think.
Right.
we
You
do
know.
that.
I think the idea that it's trying to convey and maybe is not clear enough about is that teachers shouldn't be giving just one student a gift. The idea is if you're giving gifts to students, you probably shouldn't be, singling out any particular student. Because
Because it
that
may look
can have some,
inappropriate.
yeah, that at the very least, it can look bad for you, at the very least.
I agree that that's a difficult one because kids that have a need, a teacher might bring in clothes for them or food, on the slide. So it's not highlighted to others. It's still technically a gift. But, I don't know, it's just a gray area.
And so you could actually build off of the last paragraph of this, gifts that are intended for the benefit of the WUSD should be referred to the superintendent. You could kind of reverse that and have it be. If a teacher wishes to provide something to a student because of perceived need or something like that, it should go through the superintendent or it should go through some other channel instead of it being directly between.
I think we're trying to split hairs on that one specifically because our district does have an outlet for that. At the high school and at the middle school for being able to provide, for children in need within our district. What, I forget what they call Panther,
We have the nest.
yeah,
Yeah, the net.
exactly.
I just wanna share that if we don't allow teachers to give individualized gifts, that's gonna change our culture. Do you wanna do that?
No,
I would
No.
also caution from creating a policy that is not going to be ignored, but going to be largely disregarded. Where a teacher does this and you're not gonna have their supervisor is not gonna pay attention to them because we're gonna put policy together, that policy is one that we want to enforce unilaterally.
well, and I do think that there are other policies that are gonna cover if a teacher is giving special attention to a student, you know what I mean? Like that's,
Yes.
if there is an ill will to it, that's gonna be covered. I don't think that's happening. But you know what I'm saying, like,
Well, right, and like, I think I think this policy is trying to get to the heart of teacher favoritism among a particular
Right.
student. Where our culture differs from that is our teachers are providing for students in need. Or something of that nature, and I don't wanna mess with that, you know. So I like the edits that David Schrader suggested along with deleting those first, the next couple of lines in the next paragraph, because it's redundant. So I don't know, Lori, what are your thoughts?
I was good with, I liked how the sentence that Dave put, I think striking the first and second paragraph. And then,
Ah,
sorry, I was
Alright.
trying to read it and get my thoughts together.
Lynn, can you share what you think it is that we're supposed to do? 'Cause I'm not.
If it's,
Or, okay, so we're going to strike the first, it's basically the first two sentences, paragraphs, or to strike that. And then we're gonna go over to, our current policy 4140 and take out larger gifts to employees as an individual, and gifts of more than nominal or insignificant value should be graciously declined, and add that to the policy.
I
to the
think
new
that,
policy.
I think that captures it.
Okay, do you guys think that we need to say though, if you're given a smaller gift, you can take it?
Well, that should have been left. When we took out the professional staff members may accept gifts of nominal value from students or parents, I was suggesting that we augment that with what Lynn just stated.
Oh, I thought that was already part of the original policy
That's,
that you
that's,
read.
it was, but and I understood what you said, but
That's
Lynn
not
did
what
not.
she, right.
Right,
Okay.
so you either have to keep the professional staff members may accept gifts of nominal value from students or parents and add that sentence, Lynn, or take the last two sentences from our current policy and reinsert them. The two sentences are identical.
Yeah.
I think we
You
should
just
keep,
need one of the two.
I think we should keep the professional staff members may accept gifts of nominal value.
That's fine.
And then add the one
That's
sentence
right,
that
and
you
add the
said.
one sentence, which
I think
is-
that
Right.
completes it all.
Which is fine.
Perfect.
It's saying the same thing.
It's the same,
Yeah.
just make sure you leave the nominal part in there and then add the
Yeah.
excessive.
So we're actually gonna begin the policy with, it is the policy of the board that the professional staff members may accept gifts of nominal value from students or parents. And then right after that, I'm gonna add the larger gifts. So
Okay, can I change one word?
Okay,
I wanna take out professional staff members.
Oh,
Thank you.
yeah.
yeah, that's a good
Because
idea.
we have
No,
other
we
staff
have
members,
janitors,
janitors, whatever, who
cleaners,
receive
yeah.
gifts,
Yep.
right? So,
Yep.
I just wanna say like staff members in general.
okay. One more, guys. We got
Oh.
this.
Kind of.
Staff dress and grooming.
Well, one more in this group.
In this
of
group,
this
we do have
group.
more. This week.
Tonight for this group. Um. We just, it looks like we added parts of the existing policy, or do we just add additional
Yeah,
language?
we just added there was a paragraph that we thought was important to continue with from ours.
Is that something that
Should
should,
the footnote should include?
Oh, yes. Yep, we need to do our copyright.
yep, I just
Watertown
wrote that
20.
in. Since you were seeing that.
That's another Jared mistake. It was getting late.
Anybody object?
I'm not as good as Lynn.
Any
Not even-
discussion?
Few of us are.
On that.
Nobody's
No,
close.
Whatever.
Nope, all good.
Professional staff dress and grooming, which I'm sure can be a difficult conversation at times, so. I'm thankful that we have administration that can handle that, and I'm hopefully this policy covers it, so. All right. We will continue with that other recommendation. All right, moving along, because this night doesn't need to be forever. Letter E, Neola policy development process. Let's see here. You see the timeline set forth there.
Does anybody have any questions about the process?
Yeah.
We just wanted to put it back out there and do some clarifying documents for you. And then part of the clarifying is to show you a timeline for what we're gonna try to hold ourselves to get through May. That's in that, piece there. Just wondering if there's anything in these documents that you have questions over or the process itself.
My question here is, you've got this timeline, which is very good, it's broken down, but each of these dates is tied to this specific meeting. You know,
Mhm.
I would welcome a more detailed timeline that says, when are these going to be provided by Lynn and Jared? One of the things that I have seen tonight is when board members are given the time prior to the meeting to read through these policies and provide questions in a timely manner, you have the answers, or Margaret's already been keyed up, and the amount of discussion is minimized, and that policy tends to go through quicker. If there is a way of saying, look, August 14th, you've got the finish the 3,000 person professional staff templates. August 7th, we'll
Okay, so-
have those policies to the
I
board.
can agree to this, and it's what we have in policy, right? I think it's what, 2 days prior to the meeting? Is that what it is?
2 to 3 days.
Prior to the meeting? And if it's not, then we'll just have to share. We didn't get the information in enough time, because some of it we're asking Neola, we're asking our attorneys,
So
we're
I'm gonna ask you
doing it.
this, if I decide to change this meeting, so the August 14th, if I gotta change the date for that meeting, right?
Mhm.
What are the steps to change the date for the meeting? If I wanna move that from August 14th to August 16th, what do I have to do?
Providing that we have at least 24 hours to notice it, if the chair just has to recognize.
Chair has to recognize, going to change the date, and then we have to do a public notification on this.
Yeah, 24 hours before the meeting.
So then what I'm gonna tell you is every date that we have for this committee is fluid. You can change the date on this committee, whatever works with the rest of the committee. So if you say I can't have these policies in until August 12th, then you can say, look, we're not gonna have this committee until August 19th.
Isn't that how we operate anyway?
Not right now. Right now, we drop the policies. You just said, I'm gonna have the policies 2 days before this committee meeting. What I'm saying is, you keep this fluid. If you're gonna have these policies by August 14th, you're gonna have the policies ready. Then Craig sit down and say, okay, I'm gonna give this to the board. I'm gonna give the board 5 days, 7 days, whatever. And we need to figure out when the meetings are. You need to keep this fluid, and you're gonna keep this moving quicker that way, because everybody who's had questions here that they've come answered before the meeting. Look at Tina, half her questions are answered before the meeting. She goes, no, I'm good. We're gonna keep moving. We cut off 30 minutes of conversation. We went through, it's 3 hours here. We've gone through 12 policies. At this rate, it's gonna take us 5 years to get through all the rest of 300 some.
I know.
And this is what I'm saying is that giving the board more time to have those questions presented to you and the answers provided prior to having the discussion cuts down the discussion, and I think we can cut through the policies quicker. Don't be set on the dates because they're posted. You can move them.
And my comment is that probably goes for every committee.
I agree.
I mean, and, you know, I know that we have a structure, right? And the reason we have a structure is because it's better for you guys and for us, and we'll do what we can to stay within that structure. There's just sometimes where when we're waiting from our attorneys or other people who are giving us information, sometimes we can't get them dropped in time.
And if that's the case, I would tell you too, is look, we've got the 5,000 policies that are here in March.
Mhm.
And if the 3,000 are causing us trouble, we've got to sit with the lawyer for 3 weeks. Well, can we pull the 5,000s up and knock a few of those out in the meantime? We can move those around. I don't want us to be beholden to this either on this. We got 3 out of 5 chairs here. You folks can move things around as needed to best suit and get the work done.
Yeah,
I-
yeah, go ahead, Lori.
One thing that maybe would help, cause I know you guys are doing this as quickly as you can, so like, would it be helpful if maybe you gave us like, I don't even know, like, whether it's 10 kids, say, you know that you guys are gonna be working on at least like 10 more plus. At least let us know which ones those are, so we can kind of maybe familiarize ourselves with the old ones to kind of have some idea, and then that way, when they do get on, we're a little bit more on like, oh, yeah, that's right. I remember, does that make
But remember
sense?
that the old ones,
I know,
like our old ones don't
Fairly,
necessarily line
I know.
up with the new ones.
I know,
And with the 3000s and the 4000s, basically, once they get through the 3000s, the 4000s are gonna go right through because they're the same thing.
right,
Because like for these, the 3000s, it's different. Our
Okay.
3000, Neola's 3000s and 4000s are professional staff and then support staff.
mhm,
All of our HR, we're always in a 4000. So their two are covering our one. So we're gonna kind of plow through those 4000s because we're already okaying 3000s.
Right,
Right,
So we're
and there's gonna be
right,
a
right.
slight difference, maybe in some regards to,
Five
For-
templates.
right,
okay,
So I
That'll
know,
be
so those will go fast.
yeah,
But,
so I know when we first started out, we started at a pace of probably like 5 a week where administration was able to kind of tackle them and we were able to utilize the Neil, our spreadsheet, our
Mhm.
Google Doc to kind of see that progress and then, and work through that sheet. I thought that was really helpful. I thought that worked as long as that was the pace that was, that was manageable. Because then I could see what's been worked on. I can let the committee know, hey, these policies are ready. For taking a look at and go forward and do that. So if we can kind of stick to something like that.
so just keeping up with the spreadsheet, and then just
Yeah, if we
keeping an
can,
eye on that.
if we can do that, because the
That works for me.
spreadsheet
I
will.
guess that's kind of like what I was saying, but
Mhm.
that seems like a more efficient way.
Yeah, and I'll admit, I can do better at trying to provide the questions I have to the committee ahead of time so that we can try to keep this a little bit more fluid. I mean, I think that's part of the takeaway that I got from Tina's ability to spell this all out. So anyway,
That works.
go ahead, Diana.
I'm just gonna kind of summarize what I heard. And we're on the same path, but just a little bit of differences. We have a timeline, and the timeline right now are set for the meeting dates. Yet a request was come out, if it could come a little bit in advance. I just pulled up, it's the 5000s. There's over 40 of them in that one. And so to get 40 of them with changes 2 days before is very difficult, given people's workloads, and that I think is what you were getting at. So if we could move instead of, as you guys are working through them, if it could be 5 days, but whatever it is, I don't know, but it's just, I understand. Okay, no, I don't understand, because I haven't looked at, I can empathize with the amount of work you've gone through. Okay, I can't even empathize with that.
I mean, it's nice to hear the feedback, because what you guys are trying to do is have something that's a little bit more predictable. I'm trying to give you a more predictable, but I'm also trying to balance that with, you have no idea what it takes to get you
Right.
these,
And what's gonna.
and we're
happen.
doing what we can,
Absolutely.
you know, I mean, like,
Absolutely.
And if it's a matter of getting away from like, I'm gonna do the 3000, the 5000, whatever, to go, look, we're gonna start here and we're gonna start working forward. And when we get 15 policies, we're gonna, and we're gonna send it out to the board members. And they're gonna take this, they're gonna give us all the comments back through Craig, to you through in a week. And then we'll schedule a meeting at that time. And then we'll just keep going like this and you batch them.
Yeah.
If you wanna do it that way, it's just,
yeah.
whatever works too efficiently for you for the
Right.
process.
And I think that, we're also at a place now where we've kind of truncated and put everything else in a parking lot. Because part of the issue on the others was we had other ones that were hot topic ones that we were trying to also work on, right? That also disrupts the flow, but it's not like I'm just sitting in my office and working on these and
Right.
on my time is is gathering all those people I need to, whichever policy it is that we're working on. And right now, Margaret and I are spending a lot of time together, right? More than usual, I mean, you know,
You're
just to do
bonding.
policy work, right? We're bonding over policy work, right? But what I'm saying is like,
Yeah.
trying to get all those things together, and have meaningful amount of work for you in a timely fashion. We're doing the best we can with it. I'm trying to hold myself accountable to another, thing to give you some sense of what that's gonna look like, because right now, I get it from your standpoint, you're like, well, I don't even know when these are gonna come or when they're not, and how do I set apart, you know, aside my personal time to go through them to be prepared for a meeting, right? I understand that. I do understand that a lot. And I'm trying to get us on a more predictable course with that for you, because that's gotta be hard on your end.
Do you update the spreadsheet every time you do one?
I try to. And
Okay,
I'm
I
gonna
mean-
be honest, like this last.
This
couple
last set we
weeks,
didn't.
We didn't,
Well-
because we were cranking them out the day before I left for vacation.
Yeah.
Right,
So, but can I just explain something here? So if we have this spreadsheet, right? You
Mhm.
guys all have the spreadsheet, and actually, I had shared out, a few weeks ago, I shared with everybody, I created a shared drive for board development, and to make it easy, I can put that spreadsheet, that Google sheet into board development, so you guys always have access to it there, okay? But if you follow that along, and then within the agenda tonight, I actually created some documents for you guys to help you be able to follow along on the process,
Mhm.
okay? And so the board, you're viewing the Neola, the one document is called Viewing Neola Policy, for the board members, so the board members' view of draft policies. So that's gonna step you through how to do that.
Okay.
So you know how to get in there. I'm going to move this. So you're basically, within your policies, you're gonna go to the draft. And then you're gonna go into, when you go into board docs, you're gonna go to policies, and then you're gonna go to draft, okay? And over on the left-hand side here, you're gonna see these books, and you're gonna go to this Neola policy templates for processing. And these are all of the templates. And so when Jared and I are working on these, or Jared and Margaret, like
Or
right now,
right.
yeah, we're like, let's say we're in the 3000s right now. So you can see that all of these have my initial on them. Anything that has my initial, that means that I have done the minor tweaks to them, that we've started the work. And then if Jared's initials are behind, and some of these Jared's initials actually should be there, and I need to go back and put them there. But if Jared's initials are on there, that means we've done all of that work on it. And so you can actually start looking at what we have stricken, or what options we've chosen.
Yeah, and then after it goes to committee,
Mhm,
we'll put committee first. Right?
mhm.
Well, then I tell you, Craig, you watch these, you're the chair, as those come up in those, email the committee, hey, here's the
Right.
group of policies, or here's this policies that are up. They go through it. You don't have a meeting until you get a batch of policies that the board has reviewed, because when you see your drop things 2 days prior, that's not all of them. Some of those are done 5 days prior, but you're trying to get the bulk of them done 2 days prior. What I'm saying is, when you get one done, or you get 2 or 3 done, email the committee and say, hey, look, these are ready to go. Go review them. Give me your comments back. And so then when you pull that in, then you've got more time, and then you can pull a committee meeting together and say, okay, we've got the answers from your questions. We're ready. We've got these are ready for discussion. We're gonna call a meeting and we're gonna discuss these. And here, we're gonna run through all of your answers so that we don't have to sit and talk 45 minutes on a policy.
I don't even think that you need to do that extra step of work if you communicate it out, just as Lynn said.
Yep.
And maybe advise the board, once a week, pick a day, go in and look and see what's done.
Right.
I would hate for something to come back, well, Craig didn't send this, or
Well,
you don't wanna.
Yeah, or I can, when we've done some, I can send an email at the end of the week and say, okay, these are the policies we worked at, go ahead and take a look at them. I mean, it's really.
That's not too, I think that may help, if it helps
And-
us, it
and-
helps you, it
yeah.
helps. the meeting.
And just getting an active reminder to people is going to get more response than, you know, hey, these are out there for you to look at, because board members are busy, you know, wait, I forgot this, now I gotta rush. No,
I do appreciate the pace by which I can digest them at a manageable clip, just like you guys are getting through them at a hopefully manageable clip. You
Right,
know,
if you can do them a little bit at a time. as
Right.
they
Yeah.
come out.
right,
Yeah,
because like taking a day off of work I have 10 voicemails at home right now and it's driving me nuts.
and this allows you to have absolute close, because then you're on vacation,
Mhm.
right?
Right.
We should know, hey, look, we're
Right.
gonna have a few less of these, or the board member, hey, Lynn's on vacation, she's gonna do these, I have a chance to catch up with the ones I haven't done.
Mhm.
Right.
So there's one more thing that I want to share with you, and that is the website is cleaned up as far as the board docs, as far as the public, how they can view. They can only see the policy manual, and so
Okay.
I'm gonna show you what this looks like. So, and I've also included for you in the agenda, how to tell people how they can see it in the public view, okay? So you're gonna go to your menu and you're gonna go to your, um, sorry, you're gonna go to the board agenda summaries, minutes. You're gonna go to board docs. And then this is the public view. So you're gonna tell them to go to policies, and this is all they're
how
gonna
it used to
see.
be, good.
Yep.
Good.
And this is these are our active policies. Our policies will not, you know, obviously, everything that we've worked on up to this point are in a holding pattern right now. So,
Okay.
so that's cleaned up.
Nah, that's her, I don't
Oh,
know.
I know.
There's Scott.
Well, you worked with Scott, you worked your magic, and Scott did it, maybe, but it wasn't me.
Thank you for doing that, and thank you for also putting together that kind of a tutorial sheet. Is that gonna also be available?
I can put it in that board development,
No, I mean, I appreciate that piece for the board, but that walks the public through how to find policy. Is
you
there,
want me to put it out on the website?
if there's a way that we could.
Yep, and I know that I also want to update that website to explain the Neola policy process.
Yeah.
It's just not been able to be on the forefront of my timeline.
No, I get it.
So
Yeah,
I will do that,
Everybody's got a life, right?
Yeah.
So,
We've got bigger fish to fry than that.
yeah,
so I'll add the instructions to the website.
anybody
At some point.
have any other additional comments regarding the timeline?
Not the timeline so much, but, I hate to say more meetings, Craig, but a Thursday night policy meeting, if we got 15 per what, Fred just said, let's knock them out. I mean, if they're ready and we're
You
ready,
know-
I just don't want them piling up.
Yeah.
Because that just delays the entire process. And so I'm not saying net depth, and I see how you had it worded, Lynn, which was you have the scheduled ones on here and then you have TBDs.
Mhm.
Because those would be our normal odd months. I'm not saying let's schedule them now, but if you want to schedule them now, block our time and then cancel them. Or keep them fluid. I'm just saying is that if it's necessary, let's do it, because I don't want to be I don't want to be the group that slows down Lynn and Jared or
Well,
the rest of the board.
But my question is, do you need more time because, you want more time to discuss, or because you think there's the volume?
I'm thinking about,
Because I'm just wondering how efficiently we're going through them myself.
The point being is that if we can get the questions answered ahead
Right.
of time, that'll cut down on the discussion. And you should be able to get through them quicker, so that way, you know what, 3 1-hour meetings that you guys knock through 45 policies is gonna be much better than, you know, a 3-hour meeting that we get through 20.
I'm,
We can get through.
it's not so much Craig's suggestions, just keep it in play.
Yeah,
So be prepared to pull that lever if we find ourselves drifting.
I kind of think maybe we do something that's kind of a hybrid of the two, is go ahead and schedule all of those other meetings on the off months. But then as there's additional capacity for administration to work through policy, if we can get to like, let's say 15 of them, then we schedule another meeting that particular month to get through
I
that.
just caution that don't have people target those dates, as I have to get things done by that date. Is that was the whole idea of being fluid, is let's just work through the policies when you got enough, call a meeting. Because if you put the date out there, like, okay,
Yeah.
I have to
And
get
leave
it
it-
in by this date.
And leave it to be determined as they have it written.
Yeah,
I
Okay.
see.
That's fine. But I'm just saying, don't be afraid of calling a meeting if they're ready. That was
Okay.
my.
And also remember that Neola has to have time to do their process once they,
Yeah,
need
be-
to do first read, so maybe
before
something might
first read.
not get to the first read.
Yeah.
part In the July meeting, possibly.
Right, and that's just a function of what we're,
Yep.
What we're contractually obligated to do.
right,
The other piece, excuse me, the other piece that not really muddy the waters, but it will muddy the waters is. I like leaving it fluid because those off months that don't have dates are also months that we're going to need to add the board and superintendent quarterly check-ins. So there's already additional meetings scheduled that month, so.
I know, my life is gonna be.
I'm just saying, so if we have a
miserable
single meeting, be careful, we don't wanna have two or
Already
three
started, I mean,
meetings,
like,
because we're. adding
strategic
additional
planning,
so-
facility planning,
I emailed.
referendum planning.
I emailed all the board members.
I bring this on myself.
What's your schedule
I
for
did.
August?
You did apply for the job.
Well, yeah, but I also said we need a strategic.
You know,
plan. We have-
you voted for Neil, he's the one who brought it.
Yes.
And
I-
beyond.
I said, I brought all these things upon myself. I realize that. but I'm also like,
Alright.
It's like when you think you're gonna install an
Okay.
fence.
Next,
next, okay. The next part of our agenda is talking about this evaluation of the superintendent.
I make a motion to approve.
Well, hold on, it sounds, I got a message from you, Diana, regarding this.
What I had asked was, this was one where C was accidentally left in instead
Yes.
of removed, so that was the initial change today. That was just gonna be brought through committee. And then I had asked, if you remember, the charge left to me was when we had suggested removing F. Diana, find a new home for it if we remove it. Diana looked and there is no better home for it. So, since there is no better home in any of the other policies that I found, can we put it back in? Because it doesn't really fit with Neola policies anywhere else. I did not look into the WUSD policies that don't, because I don't know which ones have matches or mismatches or whatever. And then just put that, we can leave that in a parking lot somewhere, that if there's a better place in those ones that don't line up, that we can do it at that point in time. But as I went and looked through, I did not find a better home for it. That was my responsibility.
Yeah.
F was,
Let's see.
F was the superintendent's assessment of the of board efficiency and effectiveness.
and so as we look at the actual board evaluation process, it does, when board evaluation, there's a policy on that, that does talk about efficiency and effectiveness. A little bit, so. That is 80.
What are we looking for? Like existing policy?
Yes.
Okay.
I believe it's 81.7.
So,
what?
What's your feeling on that?
Well, I keep going back to. For those of you who interviewed me, I shared that I wanted to come to a place where I felt like there was a team effort. Right, and I love how Monday's scheduled, right? Monday's topic is. I don't know, and I think, I don't know if it was you who made the topic or Fred or whatever, but it is simply superintendent and board check-in. Right? That means we're talking about how we can efficiently run as a team. Part of that may be you having to evaluate me and things that I can do to better serve the team. But it also leaves an avenue for me to say, here's some things that I need from you to, work better as a team. If it's only one way there's not a back and forth. That's a different style and I can live within that style. I prefer something different. I prefer a style that we talk back and forth. And that we're open and honest with each other about what our needs are to work together as a team. And we hold each other accountable to those high standards.
The original conversation with that was based on the interpretation of the DAPES process that we've been using. And there's nothing in that process that talks about the board evaluation piece. Yet we are also using DAPES 1.0. There's for sure a 2.0. There might also be a 3.0. We should be getting yearly updates, and we haven't been. And so that's where my meeting next week with whatever his name is from CISA 6, I don't remember his name,
Mhm.
David? John Slender.
John Slender.
Meeting with John, to kind of look at where things are at in that, but again, like Jared said, if we don't do an evaluation piece for the board and how that works together,
Yeah,
I don't know how.
I guess what I wanna ask is this, like, do you guys see that your superintendent as the CEO of a company? Or do you see him as the manager? Because managers are to be managed, right? CEOs work in concert with their board to do what's best for their constituents, whoever those are. They may be stock owners, they may be whatever it is, right?
I guess I'll take a step back and I don't really appreciate the example because I don't view running a school district as running a business. I don't. I think there's a very, very distinct differences. So, but I do appreciate what you're trying to drive at. So, and personally, I don't see any harm in having letter F back in there. So that the superintendent passes along feedback to the board for better board efficiency. I don't, I think that that's a good thing to have some sort of evaluation of the board. I think lots of boards do that and a lot of private organizations, private schools even do that. So I have no problem with that. I think it's always gonna be constructive. The superintendent hopefully isn't there to stick a finger in your eye. The superintendent is there to hopefully impart some
Operational wisdom.
yeah, and some positive feedback that we can, some constructive criticism. I don't have a problem with it. Personally. Any other thoughts?
I'm not a voter. I'm just listening.
Yeah, all right.
I know, but I asked a question, cause mine gets to a philosophy. It wasn't, I wanna know how you guys view me.
Well, there's a discussion for tomorrow on Monday, Jared.
Right.
Let's talk about policy.
Yes,
Right.
Okay.
right,
No offense.
but it informs the policy, right?
It might,
It
yeah.
might.
It might, but
So if we're gonna clarify, cause we have all night. The particular action item for policy 1240 is to add back in letter F, but still strike letter C. It looks like there was a spelling addition there that said they objectively collect. So we'll take that change as well.
Where's that?
You have it
Oh, I
highlighted
already
already.
did it.
Yep. And is there any objection to that? Nope. All right, and that will be moving forward as the recommendation.
Okay, and then that goes to second read? Is that going?
Yes. Yep. All right, the last one. The orientation policy. Policy 142.7. I got my notes on this one.
We're just adding the words or designee.
Or their
Yep.
designees, yeah,
Yeah,
thank
for
you.
their
Yeah.
designates, it's a-
Just in case they're not available.
Right.
We don't want that to go.
And that was kind of a logistic
Yeah.
thing
just,
that we had to,
Yeah, so if the board
Semantics.
president, superintendent, or business manager aren't available to help in the process, they'll assign somebody else in their stead.
okay.
it happens.
And is there any objection for that moving forward? As a recommendation, all right, and that one moves forward.
Yay. Was that a, going to second read? Did we pull this one out?
Yeah, because I think it was, wasn't that one
Already
already approved?
approved.
It's
It was-
already gone through second. So
Is
it's
it-
like.
Oh,
being
so we have to
amended.
do first reading in?
Probably,
Yes.
but it, first read as a minor revision. We used to do that on
Mhm.
Mhm.
other ones.
Okay.
Alrighty, we have other things here, but was it, policy or, okay. Future agenda planning, I think we kind of covered some of that, I take it.
The only thing that I need to make mention of is that it's been brought to our attention that our administrative guidelines around transgendered students are out of compliance, so well, I think the wishes of our administration and board, but also law. Those as well as the forms that are around them and how we administer that programming
Yes,
needs to come to August meeting.
needs to come to the August meeting.
So is there-
And it's gonna be ready. We've already been working on it to update it, so.
Can you just briefly, like, when you have a guideline, is that based off of a policy or is there actually legalities around guidelines too? You get what I'm saying? Like,
Yeah,
so if it's
I-
not compliant based on a policy or a
yeah,
law?
so administrative guidelines usually are accompanied by a policy that they support, right? This is how
Okay,
we're gonna,
Right,
this is how we're gonna implement the policy.
okay, so we're looking to
Mm,
possibly bring a new policy.
What's that?
Do we need to make a new policy based around this? Because do we have a policy that those guidelines are off of?
No, but I said usually
Right,
are around it. right?
yeah, so I didn't know what
Sometimes the policy goes slower and or isn't adopted, and therefore administrative guidelines need to be in place
Gotcha,
because there's a pervasiveness in whatever it is that is coming forward, and administration needs to know how to handle that.
Mm.
Right, and so sometimes the administrator will bring forward to the board guidelines in this realm. Okay? And those are usually passed by the board, inspected by them, passed by the board. And then codified as, you know, how we handle things. And then later on, sometimes we put in a policy to help strengthen the administrative guidelines. So it can go
So
both
we're
ways.
approving the guideline? Because I don't think we usually do anything with that guidelines, do we?
No, that's not true. So in our old policy manual, the policy manual that we have, they're usually the point ones.
Oh, true, okay, yeah,
Okay.
sorry, I think I'm just tired.
So, no, I
My
mean,
brain's like,
here's the
I
thing,
don't
in
know.
most districts, right, in most districts,
Yeah,
there is a separate
guideline,
manual that has administrative guidelines.
you're right, I think.
Here, the way it's been done in the past was, it was policy point one,
Okay,
or so on,
yeah, yeah,
right? It's very odd,
Mhm.
comparatively to most districts, right? Most districts just have a book of administrative guidelines.
yeah, right,
And with Neola, we'll have a book of administrative guidelines, and we'll also have like forms that go with those guidelines. But all those usually go through you.
All right,
I say usually because I've found in my 10 year already, my 2 years, that there are some that haven't.
I think that's where where I get.
That's where
confused.
there's confusion, and then I go, oh, we have that?
Latest policy that says administrative guidelines.
Fair
will be
enough.
Accepted as part of the policy manual.
Right, because I mean, we're not on a regular basis really looking at any guidelines very often. I don't know if I've ever looked at a
I remember.
guide, yeah.
It's the point ones, right?
We've gone through.
One
Well,
more
what-
thing for the
yes,
future
And,
planning.
and where I'm finding that in the past that hasn't come to the board is that secondary notion where an administrator saw our pervasive nature of something and wanted to codify some guidelines so that all administration were following the same,
Mhm.
right? But didn't have a policy to back it.
Right,
Where I've been, we still have taken those to the board. It seems like the past practice here was, no, we just took care of it
Yeah.
administratively,
yeah,
right?
yep,
And I don't prefer to act that way. I
No, I
prefer to
appreciate
act in the
that.
other fashion where it's like, no matter what, I'm bringing it to the board.
right.
Because,
Well, that policy's been reviewed in past 3 months ago.
Right, yes.
Where we struck the first
it
sentence.
is,
Right, right,
it
right.
is, and it will be part of our new,
That's right.
right? It'll be part of our new,
Yeah.
so,
That's what-
you know.
Right, right.
That's what we'll
It's just
do,
hasn't been a
but
very good practice, I guess, in the past.
What was your other future agenda?
So I have, notes here from Jenny Borsch that we will have to talk about, Act LI and Act 95 during policy in August
yes,
as well.
Okay,
yeah.
That makes sense.
so August is gonna be a busy meeting
Yep.
and hopefully we can keep it down.
I
as
think
far as-
that will be pretty, it's pretty,
Well, we're gonna put into practices some best practices.
Mhm.
And
but I think Act 95 will be pretty easy to get through.
we'll get
Pretty
to it.
basic.
So it
To
is
the point.
And I think the other ones changes will be pretty easy
Mhm.
too.
8:52, we are adjourned.
Thank you.
Okay.
Blow the way pretty quick. That's the longest I've ever made it through a meeting without using the restroom.
Oh, boy. Is she gonna be awake?
No, boy.
Doubt it.
My family was at Rita's, so that's.
Really?